involving Tecknologies and Enterprise.
Good morning, Mr. Knox.
My Lords, may I please you? I appear in this matter together with Mr. John Jeremies, Senior Counsel from Trinidad for the appellants, and my learned friend Mr. James Guthrie, QC, appears for the respondents.
I'm very grateful to Council for accommodating us and agreeing to sit at 10 o'clock.
There was nothing, my Lord.
I hope you've been told that we can't sit beyond 3, but with such experience and expert counsel appearing, I'm confident that we'll comfortably reach that target.
My Lords, I expect so.
So do I, Mr.
Knox. My Lords, you will have seen this is an appeal against the judgment of the order of the Court of Appeal on the 11th of August 2014, which dismissed my client's application to strike out the claim on limitation grounds. And essentially, my Lords, we take 4 points. First, the Court of Appeal was wrong to hold that discoverability of the alleged breach by the Minister of Finance, the sole shareholder, was irrelevant. It should have held that that was the test. Second, the Court of Appeal was wrong to hold, as it appeared to do, that as a matter of law there had to be some trigger which would have made the Minister of Finance embark upon a line of inquiry into whether there had been a breach. We say that wasn't the right question. The right question was simply whether, in the circumstances, it was unlikely that the breach would be discovered for some time. Come later to what that phrase means. Thirdly, we say had the correct test, thirdly we say this, on a proper view of the matter, the only result, if we're right on the law, is that the appeal must be allowed. That is because it was never alleged against my clients, either at the first round of skirmishes, if I can put it that way, or in the subsequent round, that the breach was discoverable by the minister. The only point they took was it was not, the minister didn't know about it. If the minister didn't know about it, section 14.2 didn't kick in.
I think you've missed a knot out in that.
I might have done. My Lords, can I take it as read that I did miss a knot out?
When do you say the Minister did know about it?
Well, putting it shortly, we say the Minister knew the limits of the due diligence we had done, from which it was clear that we hadn't done the things that it said we should have done. That's what it comes to. But the important point is this. At the end of the first round, the Court of Appeal specifically remitted this matter back to the judge at first instance to be heard as a preliminary question. And on the question of whether, I'll take you to this later, one of the points that was considered by the Court of Appeal was, well, maybe this will require cross-examination and hearsay things, to which the Court of Appeal said that will be a matter for the judge to decide. Notwithstanding that, when it came to the second round, the respondents still maintained their position that the only thing that mattered was knowledge, not discoverability. Now, that being the case, what started off as a strikeout application has eventually been decided as a couple of preliminary issues. That being the case, the respondent had to put forward its case on discoverability if it wanted to get a ruling in its favour on discoverability as opposed to knowledge. And I'll come to that later, but I submit, when one reads the judgments, what is noticeable, the judgments in the second round, is they talk about this in what you might call absolute terms. They talk about it as if they have decided the issues. And that clearly is what was intended by the first Court of Appeal's judgment. And so that's why I say if the respondent was to run the point about discoverability in the second round, it had to say we are running a point that this was discoverable by the minister if, contrary to our main argument, his knowledge is relevant or discoverability is relevant. They deliberately didn't do so. But the fourth point is, supposing I'm wrong on that, I say in any event, if the point can now be run by the respondent, it cannot show, the burden being on it, that in the circumstances the breach was unlikely to be discovered for some time. And I take 2 short points. The first is that it was all that the breach alleged against the appellants was that on the 17th of May they authorised the making of the investment, or the entry into the agreement and subsequent investment. That being the case, one has to focus on what was the position at that time. The position at that time was that the authorisation was subject to Cabinet approval. So Cabinet was always going to look at the circumstances before authorising it. And that, I say, is fundamental. So it was always likely, in my submission, that the Cabinet would pick up on the things that had gone wrong. or hadn't been done. The second is that it's quite clear when one goes, it's a little bit difficult to see what the correspondence means at first, but when you look at the correspondence, it's perfectly clear what the limit of the due diligence that had been done was, from which we say it was not unlikely that the Minister of Finance would find out that the other things that hadn't been done.
Can I ask Mr. Knox, if for a moment we forget about Section 14,
Yes.
when did the cause of action accrue?
That's a very nice question. You can look at it two ways. The breach, the breach of, leave on one side when the cause of action accrued. The breach of duty is on the 17th of May.
Yes.
The cause of action, now, if we're looking at it as a tort claim in negligence, which is how it's pleaded, that doesn't accrue until there is loss. Yeah. That, I imagine at the earliest date, I think is the 15th of June, when the Cabinet gave its approval to the investment. I think it's the 15th, 14th or 15th. And if not then, certainly by the 23rd of June, which was the date when the money was actually paid over.
30th?
23rd, I think.
23rd, beg your pardon.
23rd.
On the basis that the money was inevitably lost as soon as it was handed over?
Yes, I think I'd have to accept on the authorities that once there is an event which prejudices the victim, then for limitation purposes, at that point the cause of action accrues, even if one doesn't know at that point that it will definitely prejudice him.
Yeah.
But if it's tort, it depends on damage.
Yes.
So is the damage suffered the moment the investment is made? Supposing that it had turned out to be a good investment,
Yes.
there would have been no loss, would there?
That is right, but my Lord, my understanding of the authorities, and there have been quite a few, especially in financial investment, cases against financial advisors and things like that, I can't remember the name, it's a decision of the Court of Appeal about 10 years ago, where basically the idea was, if I invest in what I understand to be a medium risk investment, in fact, from the advice, but in fact it was high risk, then I've suffered the loss as at the moment I part with the money, because I've landed up putting my money into a high-risk investment when that was not what I wanted. So I've sustained immediate prejudice, a risk of loss which I wasn't prepared to bear.
Even if it turns out to be nominal, you still suffer.
Yes, you don't wait, so to speak. In other words, the court doesn't sort of delay. My lords, it's not an entirely straightforward case, because there are other cases which might suggest you apply a different test, but I think I'm bound to accept on the basis of current authorities, one looks at the date when the position of the victim has been, you can fairly say, has been prejudiced.
Well, the Nye credit analysis in the
Yes.
Samco litigation in the House of Lords suggests that you've suffered a loss once an accountant would value what you got for your money at something less than the amount of the money you paid for it.
Yes.
Yeah.
And I think on the facts of this case, I think I'm bound to accept that, one's bound to assume that that was at the latest the date of either the agreement or the investment. It doesn't make much difference in any event. But my lords, whichever way one cuts it, that was well outside the 4-year period, because I think that's, let's say, June 2005, as against proceedings begun, I think I'm right in saying, in October 2011. So it's quite a time outside the limitation period.
Do we know when it was perceived by the minister that the money had actually been lost? I've struggled to find any indication of the time in the papers. It doesn't seem to have been relevant to anybody's arguments.
No. My lords, that doesn't seem to have been gone into. I think it seems to have been fairly apparent by about 2007, 2008 that not much was happening. I think one can see that from various bits and pieces, and that the investment doesn't seem to have been producing any goods. But at the moment at which the investment was known to be lost, as opposed to not doing very well, I don't know, my lords. My lords, what I propose to do is just split up my submissions into 5 main areas. First is I'd like to look at the pleadings and the facts. Secondly, I'd like to deal with the point that the knowledge or discoverability by the Minister of Finance was enough to start the running of time. Thirdly, I'll deal with the trigger point. Was it necessary for there to be a trigger for the Minister of Finance's knowledge, if he was the relevant person? Then I'd like to deal with the procedural point, namely that this has never been, the discoverability point was not the way where it was put against us below. And finally, the point on the facts, namely, in any event, the respondent hasn't shown that the alleged lack of due diligence wasn't going to be apparent. Minister of Finance. My Lords, one can pick it up with the pleadings first in Bundle 2. But I get the amended statement of claim, which you see at the record 2, page 635.
Is that the electronic page number?
Yes. Electronic page, 635, yes.
635.
635.
Thank you very much.
And one can pick it up with the claim form. My Lords, I want to show you this because to make good my assertion that the breach alleged was simply the authorisation on the 17th of May 2005. It was not a general failure on the part of the appellants to carry out due diligence themselves, as suggested.
Are we going to be in page numbering trouble? My copy of the pleading starts, I think, on 633.
My Lords, yes.
Or you're just going straight to the meat?
Yes, forgive me, it does start on 633.
Okay, that's fine.
That's the front page.
Thank you.
635 is the claim form, which I can just show you how it's put in the claim form. You can see paragraphs 2 and 3. You can see what's alleged has been done wrong. It's negligence, and then it's the authorisation, in particular, which said to be 18th of January, but also the resolution on the 17th of May, approving the execution of the cooperation agreement. And then 3, at the time, the defendants didn't have sufficient information before them. And then the reason I take you to this is if you go over to page 636, you'll see on the claim form the 7th and 8th defendants who are not parties to this appeal. You can see how the case is put against them. The case against them is they were essentially the officers of the company, not directors, who were the people who pushed, if I can put it this way, the investment. And what's being said is, well, you did all that without yourself having ensured proper due diligence was carried out. And so I draw that contrast. In other words, the case against us is wrongful authorization as opposed to not carrying out the due diligence ourselves. And one can pick it up from the amended statement of case. Paragraph 2 at page 641 is the allegation of to exercise reasonable care. Paragraphs 4 and 5 deal with some of the history, and in particular, my Lords, you'll have noted from the record that on the 30th of December 2004, this is page 643, the Minister of Finance actually turned the investment down because of Bamboo's poor financial position. It was insolvent and so on. And then paragraph 6, notwithstanding that advice, claimant's board resolved to proceed. And then the crucial paragraph, I submit, paragraph 7, the making of the resolution, approving the execution of a cooperation agreement pursuant to which the investment was to be made on the same day. And on the same day, the agreement was executed by Mr. Julien, the first appellant for the claimant. And then the money is remitted 23rd of June. My Lords, in fact, although it's true the agreement was executed, what is missed out was that was when he sent the document back to Bamboo, he said this was subject to Cabinet's approval. So it was not finally executed, but subject to Cabinet's approval. And then over the page, paragraph 10, the breach of duty is alleged, and you'll see how it's put. No documents have been presented that showed the due diligence referred to in B had been carried out. And then it said, we knew or ought to have known that due diligence inquiries more specifically set out in the particulars and also in respect to the Tiger evaluation should have been completed before the execution. And then C, due diligence inquiries hadn't been made and we failed to ensure that they had been carried out. And then you can see the relevant particulars. Now, my Lords, of these particulars, only the first 4 are really relevant because these are the 4 in relation to which it said that our breach was deliberate. So I submit one doesn't really get into any other breaches for the purpose of this limitation point. And the first breach is it said we didn't carry out a proper due diligence exercise despite the recommendations of Dr. Vernon Paltu in October 2004. The second breach is that we didn't do the things that were set out in a memorandum of understanding of the 23rd November 2004, and it said we didn't do all those things. The third is that we didn't do what the Cabinet had directed. This is going over the page, 646. We didn't do what the Cabinet had directed at a meeting of the 12th of May. We didn't do due diligence to find out whether US 5 million was a fair value, and we didn't do any due diligence into legal or accounting matters. And then finally, it said on the 1st of June, the claimants advised the Minister of Finance that major factors were, and essentially the criticism is that letter said that Tiger had carried out a valuation when it hadn't. And it said that, well, we should have known that. Now, my lords, can I just pause for a moment on subsection 4 there, or subclause 4? I say what happened after our alleged breach is entirely irrelevant. It may be that that was a misleading letter, but that is not a circumstance in existence at the date of our alleged breach, and therefore it doesn't come into play on the case that's been put against us. I might add this. It is not alleged that my clients were responsible for the writing of that letter. It was written by Mr. Hassan Ali, who had been made president in the interim period between the 17th of May and the 1st of June 2005. And even in his evidence, he says that that letter was written on the say-so of the 7th defendant. So that letter has nothing to do with our clients. And I say it's irrelevant for the purpose of the inquiry before the court. It shouldn't be taken into account. My lords, one then moves, if I can just leave out 5, 6 and 7, except a comment that this deals with the previous efforts to get information from Bamboo, in particular about the Tiger valuation. But paragraph 11 introduces the amendment against the other two defendants, and you'll see again how it's put. Effectively, they themselves, their duty was to ensure that proper due diligence was carried out and to advise the board whether or not it's prudent to enter into the agreement. But they didn't exercise that duty because they failed to carry out the due diligence. So that's why I emphasize that. It's quite plain that there's a contrast drawn between the two categories of defendant. My lords, in the amended defence, I'm not going to take you to all of this, it's quite a long document, but I just want to draw attention to a couple of points. It's again in volume 2, at page 407. You'll see the first point that's taken on page 407 is the limitation point. And then page 415, paragraph 21, we admit the authorization given at the board meeting on the 17th of May, and we refer to a note which I'll come to later. But at this meeting, the board authorised its chairman to execute the cooperation agreement subject to the final approval of Cabinet. So the point is in issue there. And then paragraph 25, you get the date on which Cabinet authorises ETEC to negotiate a short-term loan of £5 million, guaranteed by a letter of comfort from the Minister of Finance. And then paragraph 26, you then have, and paragraph 27, you have the mechanics of the investment. My lords, just so one understands what was going on, this amended defence was served before the amended statement of claim, and it's because of what you see in paragraph 33, where my clients blame the 7th and 8th defendants, that they were then joined in by the amended statement of claim. My lords, one then comes to page 426, which is the reply, which I submit is really the central document in the case. Paragraph 2...
I'm so sorry, which page are we on?
426 at
Thank
427. 426 is where it begins, but 427 is the body of the text.
Yeah.
The loss and damage occasioned by the failure to ensure due diligence and so on. It's averred that the defendants executed the agreement and or remitted the sum of $5 million in the knowledge that full and sufficient due diligence had to be performed into Bamboo's business affairs and that such due diligence had not been carried out. And then particulars of knowledge are given. So these are the things which it said we knew about. And first of all, it said we knew about Dr. Vernon Paltoo's recommendation in his report that there had to be due diligence, in particular, the last 4 lines. Additionally, an independent verification of projected revenue and market must be undertaken to substantiate the figures. This is a critical process. So that's one thing we're said to have known. The second is we're said to have known about the memorandum, which required all the things you see on page 429, essentially financial due diligence, shareholder due diligence, legal due diligence, operational due diligence, human resources, and final evaluation of ETEC, which was going to be validated by co-investment of an established international institutional investor. And then it said, subparagraph 3, at the 46th meeting, that's, really this is just a sort of padding. This is basically just saying we approved the MOU. And then subparagraph 4, it said we knew, I suppose, or this is part of the particulars of knowledge, that the Cabinet directed the Board to carry out due diligence on 2 matters, subject to addressing concerns inter alia, 1, whether the US 5 million is fair value, 2, any relevant matters of legal accounting nature. So it said that we know all that, and then notwithstanding our knowledge, paragraph 3, and the warnings above, on the 17th of May, the ETEC Board resolved to proceed with the execution of the agreement, without, and then independent verification, and then document or information evidencing the things set out in the MOU, or the latest audited accounts, or any sufficient evidence that $5 million represented fair value. And that's essentially it. So that's what is said, that's the deliberate breach, the things we knew we were doing wrong. And then in the premises, paragraph 5, it said we knew we were committing a breach. My Lords, I'd like just then to go to paragraphs 6 and 7, because these go to a slightly different question, namely what exactly is being alleged against us in relation to discoverability and the relevance of. In my submission, paragraph 6, what it is there saying is because the appellants were the directors of the company, it followed that the company could not itself sue until new directors were appointed, and that's that. It's not running any alternative case to the effect that, in any way, this was not discoverable even by the sole shareholder. It's simply saying because the directors were not in a position, were never going to cause the company to sue, time didn't run. And then paragraph 7, consistently with that, you can see how it's put there. It's only at the date that new directors were put in, is essentially what it's saying, that the company was in a position to sue, which it did. That was in 2011. So, my Lords, if I can just summarise what I say one gets from the pleadings, is that the breach was the authorisation on the 17th of May. There's no further wrongful authorisation alleged against us. The breach was a failure to exercise due diligence the breach was not a failure to exercise due diligence, but simply authorisation. Thirdly, there's no allegation of dishonesty or disloyalty. Essentially, what I suppose is being said is we took a conscious risk but thought it was worth it, or maybe a judicious breach of duty, but it's not put on the basis of disloyalty or anything like that. And finally, there's no allegation of a breach of duty by failure to inform the Minister of Finance, or indeed no allegation that we knew we were under a duty after the authorisation, even then, to tell the Minister of Finance what was going on.
I think you're saying there is no allegation of unlikely to be discovered, non-discoverability by the Minister.
Yes.
Can you help me with paragraph 6? Because I'm afraid the court's stamp has landed on what may be some quite critical wording.
Yes.
There's a sentence that begins, the directors had no power to commit a breach of duty, and their knowledge of such breach was not the knowledge of the company. In the premises, the breach of duty occurred in circumstances where it was unlikely to be discovered by ETEC and
or the
government.
Yes.
Well, why isn't that an allegation of non-discoverability by the Minister?
Well, my Lords, because what is being said, I accept if you just focus on that bit, then that appears to be what it's saying. But in context, what it is saying, especially with paragraph 7, it's saying the government couldn't find out until new directors were appointed.
Yes, but that contains an allegation, doesn't it, of non-discoverability by the minister until he gets the crown jewels through his newly appointed directors.
But the premise of that, in my submission, is that the only people who have the relevant knowledge are the directors, as opposed to the Minister of Finance. Well, I accept one could read it as saying, could possibly read it as saying, but one has then to look at how the evidence panned out and what was suggested in the allegations. But in my submission, on a proper reading of this, what is being said is only the appellants, only directors could have the knowledge, and until new directors were appointed, the government itself couldn't find out what was going on.
That's fastening on the words "in the premises" at the beginning
Yes.
of the sentence that Lord Briggs has just read to you, is
Yes, yes, yes. And also looking at the context in paragraph 7. Yes. And my lords, I do submit one has to carry on with after the in the premises, unlike to be discovered by ETEC and or the government of the Republic of Trinidad, until new directors and or board of directors were appointed and legal advice given as to whether action could be taken against them. And that, I submit, is important. In other words, the sting of this allegation is this couldn't be discovered by the company until new directors were appointed. But, my lords, any doubt on the matter, I'll come to this later, any doubt on the matter is put, I submit, beyond any argument when one looks at actually how the point was put by the appellants in their evidence and in their written submissions, where it's quite plain what they're saying and not saying. My lords, just dealing with the facts, if I may briefly. First, the company was incorporated in 1999. In July 2004, it began considering a proposal to invest in bamboo. And in October 2004, Dr. Paltu provided his report. And the material bit, if I can go to that, is in bundle 1 of the record. It begins at page 234. And essentially you'll see from the second paragraph that the idea was that the government was going to get, in return for its investment, about 14.9 to 22% of the company. That's what the second paragraph is saying, in return for an investment of $5 million. At the foot of the page is a recommendation.
Which page are we on?
Sorry, 236, forgive me, my lord.
Sure.
So the second paragraph explains the nature of the proposed investment, $5 million in return for 14.9 to 22.1%. And then, final paragraph, a recommendation that ETEC pursue an ownership option in this enterprise, pending a due diligence exercise on the finances, capabilities and track record, and so on. Then the paragraph that is relied on in the particulars of claim is at page 242. Specific project issues. Since ETEC and by extension the government is being proposed as an equity holder, the due diligence must be done on bamboo to confirm the statements of their finance, capabilities and track record as outlined in their proposal. Additionally, an independent verification of projected revenue and market must be undertaken to substantiate the figures provided. This is a critical process before ETEC makes the financial investment. And then page 243, you'll see the recommendations and way forward. And this includes, amongst other things, page 243, the first bullet point under paragraph 5, a comprehensive due diligence of bamboo in order to assess its finance. On the 17th of November 2004, the Memorandum of Understanding was executed, and one can find that, page 244, immediately following. And you can see just in very brief terms what the proposed project was all about at page 245, the second paragraph of 245, the nature of the, what was then being called the joint enterprise of some sort, or joint venture. And page 248 sets out what the parties were going to do, and you'll see there's a due diligence program, fairly aggressive due diligence program set out at page 248. And this is what is referred to in the pleadings the various different types of due diligence which is anticipated will be done. And then page 249 explains the nature of the investment of $5 million, how it's going to be invested, and the terms on which it's going to be invested. My Lords, this memorandum was executed on the 17th of November but, by Mr. Julien, the first appellant, but it was ratified by the board on the 23rd of November, and you get that from page record 1, page 203 to 4. It was decided at that meeting on the 23rd of November there had to be, quote, physical due diligence, which would involve a representative of Mr. John Su Ping Chow on behalf of ETEC and the Permanent Secretary of Ministry of Finance actually going to Hong Kong and China, as they did in December 2004. And at the end of that, the Minister of Finance was pretty unimpressed. And you go to page 2, record 2, page 482. And you'll see a letter written by the Minister of Finance to the first appellant, and they conclude that the company is insolvent, has a short track record and lacks proper management structure. So all that's known. My Lords, it's important, my Lords, I mention all this because if one gets to the stage of looking at what were the circumstances on the 17th of May and what was likely to be discovered, well, the government knows from the off that there are all sorts of problems with this company. And then page 483, you'll see a note which had been prepared by the Ministry of Finance about the due diligence it had undertaken. And you can see at page 485, the third paragraph, they note that the financial statements have been prepared on the basis of accounting principles as a going concern, but that may not be appropriate because of the significant losses up to the 31st of March 2004, and it then goes on to say what the losses were as at that date. Adjustments will have to be made if it's not able to continue as a going concern. This next paragraph, and the final paragraph, 485, the director has confirmed his intention to continue to provide financial support, and so on. So it's all dependent on him, really. And then over the page, second paragraph, Bamboo has entered into a memorandum of understanding which provides for collaboration and so on. My Lords, I mention that here because it's clear that the Minister of Finance knew about, I submit from this, knew about the memorandum of understanding, and it's likely he would have seen what the memorandum of understanding required. And then finally, in view of the poor state of financial state of the company and so on, the government should not invest. But perhaps at this time, however, the government may consider investing in the subsidiary, which is to be established in Trinidad. And then there's a Dun & Bradstreet report, which is also, which the government also had at this point. Page 489, you'll see the Permanent Secretary to the Ministry of Finance is provided with a Dun & Bradstreet report on this date. and that you find that at page 490, I only need to take you to one or 2 points in this. 491, the risk predictor for the company is 1, which indicates 8.5 times above average risk. The likelihood of a company having financial distress over the next 12 months is 29.4%. And I don't think there's anything else in this I need to take you to. Perhaps I can just go to 499. There was just one director whose name one does see in correspondence. The principal is Mr. Jean Kim. And over the page, nothing detrimental against him, halfway down the page. My Lords, just continuing with what happened, on the 18th of January 2005, the board decided, having had a presentation from Mr. John Su Ping Chow, that it did want to pursue the investment. And then in May 2005, 9th of May, he made a presentation to the Finance and General Purposes Committee of the Cabinet. And my Lords, one can see basically what he told them. If you go first to pay about record 2 at 577, this is an affidavit sworn by Beverley John on behalf of the appellants. Paragraph 9. With respect to ETEC's investment, Mr. John Su Ping Chow presented the results of a due diligence exercise he performed on BNL to the Board of Directors of ETEC and later to the Finance and General Purpose Committee. My Lord, that's a reference to, we can see this from the record, to a presentation on the 17th of January. I was present at both presentations. At each presentation, Mr. Su Ping Chow was asked a number of questions by the members of the Board of Directors as well as Ministers of the Government. And it was chaired, and it goes on to say who was there. Now, my Lord, what we can tell from this, that assuming he made the same presentation to, which this appears to say, the same presentation to the Finance and General Purpose Committee as he had to the Board of ETEC, one can see what that was if you go back to page 517. Because this is what he presented to the Board of ETEC on the 17th of January. It begins at 515, forgive me. My Lords, just for your note, we know this was presented to the Board of ETEC on the 17th of January from record 2, page 455.
And is this still talking about the Chinese company rather than a Trinidadian subsidiary?
Yes, strictly, it's a company registered in the Cayman Islands which operates in Hong Kong, which in turn has a Hong Kong subsidiary, rather misleadingly, called by the same name.
Yes.
But this is the same, yes, this here is talking, well, this due diligence report is talking about what you might call the head company, that is, say, the Cayman Islands company, which operates in Hong Kong.
Right.
And here, this is what he told both the board in January and the Finance and General Purpose Committee in May. You see, it explains what Bamboo's business is. And then importantly, 517, improving financial picture. My Lords, can I just ask you to note one thing? It's apparent from other references in the record that when you see 2001, 2002 and 2003, what they're talking about is 2001 means the year 2001 to 2, 2002 means 2002 to 3, and 2003 means 2003 to 4. And the year end appears, at least according to draft accounts, to be 31st of March. And what he's saying here in relation to the improving financial picture is, well, you can see what he says, what the total losses to date are. Then going over to page 518, he explains what the revenue expenses trend was up to August 2004. and then he explains.
I'm sorry to interrupt, but
Yes.
it's rather confusing us. This report is not about the same company as the Dun and Bradstreet report.
No, I think that may be right. It's the Dun and Bradstreet, I think you're right, my lords, the Dun and Bradstreet report, I think, is in relation to the subsidiary rather than the, forgive me, my lord, yes, I should have made that plain, in relation to the subsidiary rather than to the head company. But here, he's setting out what the financials are.
And I'm sorry, just for the sake of completeness, the company that... Yeah, no, I think I'm confusing myself. This is the report of the people who went out to Hong Kong,
Yes.
and they're reporting on a company that trades there, but is actually a Cayman company.
Yes. It is remarkably confusing. There's a Cayman company trading in Hong Kong,
Yeah.
which has a subsidiary which is also trading in Hong Kong.
Yes.
And which have identical names.
Yes.
Just to help.
Just to help, yeah.
Yeah.
But, my lords, as I understand it, what this is the financials. When it says, I agree, my lords, it doesn't in terms say this is the head or the subsidiary company, but one takes it that this is the head company, because that's the company in which the investment is going to be made. Page 518, they have the consolidated, again, which would rather suggest this is the head company, consolidated revenue and expenses trend for the period January 2002 to August 2004, and has various different levels of gross profit, normal operating expenses, and so on. I emphasize here, this is quite obvious that this is all he's got. There's no suggestion that he's been verified. And then page 519 is an explanation of what the management structure is proposed to be. Page 520 is essentially about the long-term potential increasing efficiency and so on. And then 521 is essentially what he's saying, well, this is what I recommend. Now, it seems this is what he tells A, the board in January, but B, the Finance and General Purposes Committee in May. And the reason I emphasize that is it's pretty obvious that not much actual due diligence has been done except what he's saying here. For instance, there's no suggestion there are any audited accounts. There's no suggestion there's been any verification of these projections or anything like that.
This seems to be a PowerPoint presentation. It must...
Yes, PowerPoint presentation. On the 10th of May, there is communication between my clients and ETEC to the effect that they are expecting to be able to enter into the agreement. And one can see that in the record of Bundle 1 at page 89, page 88 and 89. One starts at, I think, 89, well, if one starts at page 89, you have the email from ETEC attaching a draft cooperation agreement. I'll come to that later if I may. There's a request for particulars of court cases in which Bamboo Networks is involved, so one draws the inference that's what the Finance and General Purposes Committee were interested in on the 9th of May, and asking for some things to be included. You'll note, all in all, the feedback today was good. Today must be a reference to the 9th of May. This email's been written very early on the 10th. And we have approval. And then over the page, you'll see the letter that was actually sent, enclosed with that email, which notes in terms, in the first paragraph...
So which page are we on now?
88.
Thank you.
So the letter enclosed with that email makes it plain that the authority to execute a cooperation agreement is subject to a final confirmation of the approval of Cabinet. And then going back to page 89 at the top, you see the reply from Mr. Jean Kim of Bamboo with a revised contract. So that's the position as it stands on the 11th of May. And then, my Lords, if I can now go to record 2, page 549. And this is a Cabinet minute. Can I just ask you to note the number at the top, because it comes in later.
I'm sorry, the page?
549.
Thank you very much.
And the number...
1271.
1271 is important because it's referred to in Mr. Hassan Ali's letter. So obviously this information had got, this minute had obviously been, was later, I'll come to this, was obviously later sent. So that's how Mr. Hassan Ali knows the number. And I'll explain why that matters. But you'll see the heading Equity Investment and so on. Note TI, my Lords, we don't have that in the record. Together with the recommendations of the Finance and General Purposes Committee, again, we don't have that. It was considered, but we can gather something about that from another document. And then you'll see what's agreed. The Cabinet agreed in principle the establishment of a high-value business process outsourcing services company in Trinidad and Tobago. B, that ETEC continue to hold discussions with Bamboo, such discussions to address certain concerns, including, one, whether $5 million is a fair value for its share in the company, two, any relevant matters of a legal or accounting nature, including the latest audited financial statements and information. My Lords, I emphasise that here because the circumstances, as at the 17th of May, was that if there was, that the Cabinet was going to be looking to see what due diligence had been done on these issues, and it was likely to see that certain things hadn't been done, and if it hadn't been done, we're prepared to take that risk. Then C, they also want to be satisfied that the shareholders' agreement for implementing the project be submitted for approval. Then over the page, Cabinet noted that ETEC would continue its research for other companies in pursuance of its mandate to promote and facilitate the knowledge-based industries. My Lords, I just want to make this point, which is a point made by my learned junior, which is there is a difference between government organisations investing and what you might call private organisations investing. A government organisation has what you might call the broader public interest taken into account, in this case, of building up effectively a technologies industry of some sort, and therefore is prepared to take greater risks, because everyone knows that technologies, if I may put it that way, that technology companies tend to be high risk. And so there's a sort of thread running through my learned friend's case that, well, this is all quite risky, to which we say, but it may very well have been. And it doesn't follow from that that you draw the inference that Cabinet didn't know what was going on. My Lords, one then has the board meeting of the 17th of May, which I should take you to, which is back in bundle 1 of the record, at page 213. It begins at page 213. You'll see it's the 17th of May. The relevant passage is at page 225, and this, my Lords, is what you might call the best evidence we have of the alleged breach against my clients. The foot of page 225, under the heading Any Other Business, the proposed investment and cooperation agreement between Bamboo Networks and ETEC was tabled. My Lords, that appears to be a reference to the cooperation agreement. It's not entirely clear whether there was a separate investment agreement. There are some suggestions in the record that there was, but it may not matter for present purposes. Sometimes it appears to have been treated as if there was just one agreement, but other references suggest there were two agreements. But we haven't got the investment agreement if there was a separate investment agreement.
Cooperation agreement is the memorandum of understanding, is it?
No. The cooperation is a separate agreement. I'll come to that in a moment. You'll see that the chairman gave a brief overview of the investment and so on, and the presentation of the investment made to ETEC's line minister. My Lords, that is, as I understand it, the Minister of Trade rather than Minister of Finance. The way it works is that it's up to the Prime Minister to, as well, allocate various ministers to different companies, and the Minister of Trade was the line minister for this, although the Minister of Finance is the sole shareholder. And the presentation made to the Finance and General Purposes Committee on the 9th of May, and the conditionalities imposed by that committee. The Chairman reported that Bamboo Investment had gone before Cabinet for its approval. However, he was still awaiting Cabinet's formal decision on the matter, and in that regard, he referred the Board to an unconfirmed decision of Cabinet that the shareholders' agreement for implementing the project be brought before Cabinet for its approval. So it seems at this point that he's not in possession of any Cabinet minute, but he's obviously been given some sort of indication that it's likely to be approved. After considering the note on the proposed investment, the Board authorised the Chairman to execute the cooperation agreement and the investment shareholders agreement as negotiated with Bamboo, subject to the final approval of Cabinet. My Lord, the note which is considered in the second paragraph on page 226, I'll come to later, but it was a note prepared by Miss Beverly John on the 16th of January. I'll come to it later because it was in fact a note that was sent on to the Cabinet. So I'll deal with it in that context so you can see what the Cabinet was told about what had happened. And that, staying in the first volume of the record, going back to page 88, on the 17th of May, Mr. Julien, on behalf of ETEC, writes to Mr. Kim on behalf of Bamboo. The Board has authorised me to execute the cooperation agreement and the investment agreement as negotiated with Bamboo. This authority is subject to a final confirmation of the approval of the Cabinet of the Republic and so on. On receipt of this document, I will appreciate it if you can convey to me the names of the other investors and the value of their investment. We also need to finalise the equity share ETEC will receive for the $5 million.
Sorry, could you give me the page for that?
88.
Thank you.
So he makes it plain at that point, this is subject to, he says basically I've got the approval, but it's, we're prepared to execute the agreement, but I need final confirmation. And on the next day, Mr. Julien writes to the Cabinet Secretary, which you can see in bundle 2 at page 557. And my Lords, I submit this is a very important document because here, what I submit is going on is the Cabinet is being told what due diligence has been done, from which I say it is perfectly obvious what hasn't been done, or at least discoverable what hasn't been done. You see he's writing to the Secretary of the Cabinet. I have been informed that the unconfirmed minutes of the Cabinet meeting required that the shareholders' agreement for implementing the project must be brought to Cabinet for the approval of Cabinet. And then on that basis, I'm submitting 30 copies of the A, note on proposed investment, and the cooperation shareholders' agreement. Now, the note on proposed investment is, you can find at bundle 1, at page 353. And if I can show you that, that is important. It's an exhibit to an affidavit of, I think, Mr. Eugene Tier. No, I think it's an exhibit to the defence, sorry. The exhibit's at 352, but the actual body begins at 353. And at 353, you'll see note on proposed investment and cooperation agreement, and so on. And you'll see project concept, $5 million investment in return for various things. And then 354 is the second page. Risk mitigating factors. It's said to be a right to recover the $5 million if Bamboo doesn't fulfill obligations. 354. And then the scenarios put, ETEC invests, Bamboo doesn't fulfill, ETEC to recover $5 million, share allotment to be revoked. Then a different scenario, is Bamboo pulls out after 2.5 years, and so on. And then salient features of Trinidad Cooperation Agreement, ETEC to make conditional investment of $5 million to be made within 7 days of signing of the investment agreement, Bamboo's to establish local company, and so on. If it fails to do so, we can recover the money. Local company to be owned by Bamboo, and so on. Then going over the page again to 355, various other, as it were, aspects of the agreement are set out at the top of the page, and again, D and E. And then paragraph 4, specific conditionalities of Finance and General Purposes Committee. In other words, these are the conditions imposed. A detailed curriculum of the training programme is attached as A. Now, my lords, this was also attached in the Cabinet Minute, and you can see A, this is the project rollout schedule, which is basically the training programme. In other words, how we're going to train young men and women in Trinidad to, as it were, get up to speed in the technology field. And that's Appendix A. You can see that at 356. Dropping down to subpara 3, the schedule for training and employing local management is set out at Appendix B, and that, I think, not sure we have Appendix B, maybe, oh no, forgive me, we do, rather misleading, I think that's right at the end, at 374. As I understand it, this is Trinidad software curriculum and so on.
You mean 374?
374, I think. It's a sort of a little schedule for training and employing local management. So this is not a particularly important document, but really it's C and D that matter. For a summary of the court matters which have been filed against Bamboo is at C. This hasn't been independently verified, and C is at page 358. You can see at the top of 358, attachment C. And you'll note what's said at the top. Bamboo's maximum exposure to existing litigation is $42,000 US. And then right at the foot, these suits are effectively firewalled, and the maximum exposure the company faces is what is presently retained in that entity. The restructuring, so in other words, your investment's going to be safe. And then finally, going back to page 355, subpara 5, the projected improvement in Bamboo's profitability is shown in attachment D. And that, my lords, you can see at page 37, begins at page 373, all indicators moving in the right direction, total losses to date and so on, debt to equity, and a few more bits and pieces of information given. And then 372 would appear, in fact, to be the second page, but out of order. Bamboo's financials, improving financial position, picture. And you'll see here what's being said about the improving financial picture, including year to date. And my lords, you will note, my lords, the year to date is 2004, but we're now talking about 2005. So that's why I say these dates indicate 2001 to 2 and so on. So 2004 is 2004 to 5, 9 months. And you'll note underneath it puts unaudited results through December 2004, financial year ends March 2005. Someone, don't know who, has added, where are these financials? Now, my lords, I emphasise this because all these documents, I'll come back to the Cabinet Minute in a moment, or the note to Cabinet, all these documents are being shown to Cabinet at the time, and I submit it's perfectly obvious this is the extent of the due diligence done.
Just what does that asterisk note mean, Mr.
The asterisk is referring down to the foot of the page.
No, it's what's at the foot of the page that I'm asking about.
Yes.
It says that the result, does it say that the results in December, the 04 results are unaudited?
Yes, my lords, well, I would understand that. I mean, these are unaudited results, because obviously they're not going to be audited up to, for 9 months.
Right. But had any of the earlier years been audited?
My lords, it's not clear. I think all I can, it may be apparent from one other document, but it's not clear to me whether they had. I don't think it's a specific criticism.
I mean, some people might read that page as suggesting that they had, and
Audited.
drawing the distinction between
Yes.
audited ones for the earlier years and unaudited ones for 04. Perhaps.
Yes. My lords, I don't think it said against us that there were, I'll have to check this. We know there are some draft accounts for the year ended 31st of March 2005,
Yeah.
which, well, no, in fact they were finally audited. So, my lords, my understanding, but I'll have to check this, is that there were audited results for previous years.
Qualified or?
My lords, I don't think it appears whether they were qualified or not. But, my lords, the simple point I'm making is one can see from the information being provided what the nature of the due diligence that has been done as against that which has not. My lords, going to page 557, was going back to what was provided to the Cabinet. I've made the point that the note on proposed investment is what I've shown you at 353. The cooperation shareholders agreement is also being provided. My lords, that is at record 1, page 256. And then the note continues, the Cabinet may wish to note that the agreement took into consideration all of the expressed concerns of the F&GP, and pages 2 and 3 highlight the stringent conditions that ETEC has insisted upon. My lords, that may be a mistake for clauses 2 and 3, but one can see the conditions that are insisted upon at page 256 to 257 of the first bundle of the record. And it's really 2.1, the first part of 2.1. Condition is essentially the establishment of a local Trinidadian company with the right to terminate and recoup the money if that doesn't happen. My lords, going back to 557, the other attachments are the project schedule. My lords, I've shown you that. That was Appendix A at page 356. The status of litigation, I've shown you that. That was Appendix C at 358. And then over the page, 558, a summary of Bamboo's latest projection. That was Appendix D, which I showed you a moment ago, at 372 to 3. Attachment 2, we don't have, but that addresses the governance of the company. And attachment 3 is a software curriculum, and that appears to be what you see at page 374, which I showed you a moment ago. And continues, the board has reviewed all these matters in detail and confirmed that it's prepared to proceed. Now, I emphasize all this because I submit it's fairly obvious from the information being provided what hasn't been done. There's no provision of audited accounts, certainly for the latest year, and there's no valuation that's been provided. There's no verification of independent verification of projections or anything like that. It's not being said there have been. My lords, on the 1st of June, Mr. Hassan Ali writes his letter, which you see at page 291.
Did you say 551 or 251?
Sorry, 291. 291.
Sorry, I misheard you. Thank you. Yep.
And he here is addressing the question of fair value. So And what you'll note is that he's obviously got the cabinet minute now, because he refers to the number. And my Lords, one draws the inference that it's been made known to ETEC that they must provide this valuation, because so far the cabinet hasn't got it. And the reason I say that's important is this shows that actually the cabinet realised, let's say on the 18th or 19th of May, that it still didn't have the valuation. So the circumstances in which we made or authorised the investment, not only was it likely that the cabinet would realise we didn't have a valuation, it obviously did realise we didn't have a valuation. And then he answers the question about the valuation, and he explains how that there had previously been an initial valuation, and so forth, in the bullet points. And then he concludes the final two paragraphs. The major factors that contributed to the acceptance of the investment terms of Series C are the valuation by Tiger Tecknologies, a fund that has a historical rate of return, and so on. Consequently, ETEC is proposing to purchase 8.33 million shares odd at $0.60, 60 cents. And then, just going back, you can see the reaction to that, at least to the Ministry of Trade, in Bundle 2 of the record at page 564. Note for Cabinet. And this is a note presumably prepared after it has seen Mr. Hassan Ali's letter. And you'll note the Cabinet number is 1480. And it recites the effect of 1271 in paragraph 2, the previous minute I showed you. Then paragraph 3, Cabinet is asked to note that ETEC has been holding discussions with a view to concluding its investment. ETEC has provided a status report, a note on proposed investment. That's a reference to what was provided on the 18th of May. A review of the note indicates, and it goes on to set out what the review of what they've spotted or what they've noticed from the note. And then paragraph 5, the parties have now agreed ETEC will make a conditional investment and so on. And then 6, in accordance with the Cabinet decision, ETEC has also now submitted a cooperation agreement. This identifies the role and responsibility. And so that deals with the concern in paragraph 2C. And then 7, Cabinet's asked to note further that the report provides information on the legal standing of bamboo networks and so on, essentially litigation. And then paragraph 8, appendix 3, has a correspondence from ETEC, provides they're satisfied, and that's about the valuation. That's obviously Hassan Ali. And ETEC's written confirming that the funds are available. And so paragraph 10, the Ministry of Trade and Industry recommends the making of the, to note the documents in satisfaction of conditionalities as they relate to the valuation of shares, the provision of the most recent accounting and legal information, the submission of the shareholders' cooperation agreement, and to authorise the investment. And then the Cabinet then considers the matter at page 569 on the 2nd of June. My Lords, you'll see at the top, note T1 2005 is considered. That's the document I showed you at 564 a moment ago. And then it goes on to talk about note 1271, which is the one I showed you at 549. And then it goes on to say what was in the note we don't have, but it essentially says, just to summarise what the note says, outline of the investment. And it notes over the page the intention to make a conditional investment, notes the cooperation agreements, split of responsibilities, and then it finally notes the letter from the President of the 1st of June, saying it's satisfied about the $5 million valuation. And it goes on to note, subpara 2, importantly, Bamboo has indicated that while it lost a certain amount of money in 2003, That was lower in 2004. Financial indicators point to improving investor confidence. And they agreed that. Now, my lords, what I submit one gets out of all this is the Cabinet knows the limit of the information it's been given. It's not sort of asking for any further information, and it's satisfied to make the investment on this basis. If it's alleged we should have done more due diligence, and I say, well, the Cabinet, it was discoverable by the Cabinet at the very least that we hadn't done it. And the reason it was discoverable was they were interested in it, very interested in it, and we were providing information to them. And it knew what we had obtained. It must have been fairly obvious from that what we hadn't obtained. So it was to say it was unlikely the Cabinet would find out, I submit, is simply not right. It was likely, if it was interested, that it would find out.
Yes, well,
But I say I don't have to, but I'm just anticipating my submission. Can I just finally go to page 574? It's on a slightly different point. This is the eventual letter of comfort which is given to the bank which advanced the $5 million. It's from the Minister of Finance, who I understand, in fact, is the Prime Minister as well, Patrick Manning. You see that signature. He gives an assurance at the foot of the page: I am in support of this arrangement and will take all necessary steps to ensure that the company is provided with funds to fulfil its obligations under this facility. My Lords, I submit that's important because there was never any question of ETEC being insolvent. And I should say ETEC is still in existence, because it was always going to have the support of the government in relation to this investment. That is to say, the creditors for $5 million odd, if it all got lost, were going to get their money back from the government anyway. My Lords, if I can now deal with my first submission on the law, namely shareholder knowledge or discoverability is enough to make time run under section 14 of the Act. My Lords, one has the Act in bundle 1 of the authorities, and it's in the same terms, the relevant provisions are in the same terms as our Limitation Act.
Do you have an electronic page?
Oh, 1170, forgive me, my Lord. 1170. Sorry, not 1170. 1177. That's where it begins.
Yeah.
Paragraph 3, you'll have seen, it's common ground that you have a 4-year period for actions found on contract or quasi-contract or tort. So, we then have section 14, which is in the same terms as our section 32. 14.1a is the relevant introductory part, if I can put it that way. Page 1188. Subject to subsection 3, where in the case of any action for which a period of limitation is prescribed by this Act, either B, any fact relevant to the plaintiff's right of action was deliberately concealed from him by the defendant, the period of limitation shall not begin to run until the plaintiff has discovered the fraud, concealment or mistake, as the case may be, or could with reasonable diligence have discovered it. For the purposes of subsection 1, deliberate commission of a breach of duty in circumstances in which it is unlikely to be discovered for some time amounts to deliberate concealment of the facts involved in that breach of duty. Now, the Court of Appeal held against us on this.
Well, and also it's important to note that what this is all concerned with is the plaintiff's discovery, or,
Yes.
or the point in time when the plaintiff could, with reasonable diligence, have discovered it.
Yes.
So the focus is on the plaintiff.
Oh, yes, I agree with that. And the question is whether, for that purpose, one can attribute the minister's the minister's knowledge, or in a case like this, where there is no one else who can know, does one attribute his knowledge or not to the company? And one construction could be, well, tough luck, as we're only the company can only know through its directors. It doesn't matter what the minister knows. That's one construction. The other is, well, hang on, if one rules out the directors as being able to have the relevant knowledge, but the minister does know, what then? How does one construe the act in those circumstances? And that in my submission, is the question. Now, my lords, the Court of Appeal found against us essentially on two grounds.
Just before you go on,
yes.
Can I just check, is there any equivalent to our section 21, that's a limitation periods for actions against trustees, because directors would prima facie be fiduciaries of the company,
yes.
and therefore, I think what in English jurisprudence has been called Class A trustees or something of that kind in other cases. It appears to be common ground between you that actually, subject to postponement under Section 14, we're into the ordinary tort 4-year limitation period.
Yes, my lords, I don't think there is an equivalent to Section 21, but what I would also say is, even if there were, it wouldn't apply, because this is not a case, I think I'm right in saying...
Where the breach is fiduciary.
Of course, it could in theory apply, but we have to be the recipients of the money in some way. The mere fact you act in breach of trust as a trustee, let's say I mistakenly or wrongly, in breach of trust, give money over to a third party. In my submission, even in England, that would attract the 6-year rule as opposed to the 12-year rule.
I think it attracts an express 6-year rule under Section 21 or thereabouts, but wherever it is. Yes. But anyway, there doesn't appear to be any equivalent.
No. I don't think there is, but my lords, in any event, I would submit we're not here. The case hasn't been put against us on terms of breach of fiduciary duty or breach of trust. It's simply negligence.
Yeah.
My lords, essentially, the Court of Appeal found against us, I'm conscious of the time, if I can just summarise it, on two grounds. First of all, that the Minister of Finance's knowledge or discoverability was, in principle, not capable of being attributed to the company. It can act only through directors. Therefore, whatever the Minister of Finance knows or could have found out is, as a matter of law, irrelevant. That, in particular, is in Madam Justice Rajnath Lee's, Justice of Appeal Rajnath Lee's judgment, Record 3, page 1070, paragraphs 96 to 97. Essentially, the Minister of Finance isn't the company, end of. Secondly, it was held, again by Madam Justice of Appeal Rajnath Lee, at page 1070, Record 3, 1070, para 99, that anyway, it would be inappropriate in the case of a state enterprise to allow the Minister of Finance's knowledge to be attributed on the basis that that would only lead to corruption, or at least, she doesn't use that phrase, but on the basis that it's notorious that state enterprises tend to be rather soft on the directors they've appointed to the government tends to be rather soft on directors who they've appointed, and therefore you shouldn't, so to speak, allow an extension of the limitation period in circumstances like that. That's at paragraph 99 of her judgment, and also Mr. Justice of Appeal Barreau agrees with that at paragraph 22 of his judgment at Record 3, page 1038. So there are essentially two points they take. My lords, dealing, if I can, first with the first point, in this case, can the sole shareholder's knowledge be attributed to the company in circumstances like this? I submit manifestly the answer has to be yes. And the question I submit is this. The right question is, how are the Limitation Acts supposed to apply where A, the directors ex hypothesi will not bring an action on behalf of the company against themselves, but B, the sole shareholder, or at least the shareholders by a sufficient majority, can? And certainly in a case like this where there's just one shareholder. What is the position?
Where they can?
They can.
That's how you put it.
Yes, they can. Well, indeed, it maybe must, but I mean, they certainly can. They have it within their power to do so, and it is in their interest to do so.
And is there a material distinction between the ability of a minority shareholder to bring proceedings?
Well, it may be harder. My lords, I wouldn't necessarily rule out a minority shareholder, but I would say, and there's some American authority, one of the considerations one has to consider is, well, how easy is it for the shareholder to do anything about the problem? If it is very easy indeed, and indeed, if he has the power, as I would explain in a moment, if he's got the power anyway to ratify or to bring proceedings, I submit that is that. But whatever the position might be in other slightly more questionable cases, I submit if it is, when you're looking at a sole shareholder who is in a position to sue, and it is in his duty to sue, well, that is it.
Duty to whom?
Sorry, well, it could be, in this case, the Minister of Finance. Let us say the Minister of Finance.
Duty to whom?
Well, it might be in his case the duty to the government. I mean, it might be, he might be. But the real point is, it's in his interest. The Limitation Acts proceed, in my submission, on the premise that people do what is in their interest. They don't necessarily do what's their duty, but they certainly do what's in their interest. And if they can protect their interests, then time runs.
Is this a special rule which applies only where the defendant is a former director of the company?
Well, my lords, supposing the position were that the directors hadn't done anything wrong, the directors, for whatever reason, aren't interested in suing, or don't know about anything, but let's assume for some reason the sole shareholder does know about something. What is the position in those circumstances? Now, I would say in those circumstances, it may be difficult for the victim, or rather for the person being sued, to say, well, look, the sole shareholder knew about this, but the director didn't, because depending on what the articles say, it may be that the management of the company is solely vested in the director, and there's nothing the shareholder can do about it. The sole shareholder wouldn't be in a position just like that to trump the director. But we're not in that position. We're in a position where it's a question of whether the sole whether the sole shareholder can bring an action on behalf of the company against the director.
So it's a rule that applies where it's a rule which applies only where a shareholder is capable of has control of a company, or is in a position to exercise control of a company.
And there's no one else who can do on behalf of the company no one else who can protect the company's interests.
But if that's right, why wouldn't the same apply to an action against a third-party defendant?
Well, my lords, I'm happy to push the point as far as that, but I say I don't have to go that far. The third party, if you have a competent director, then the third party might be able to say, well, look, there was a competent director whose decision it was whether or not to bring this action.
But you're postulating a situation in which by definition the director doesn't know and hasn't the means of knowledge, otherwise the limitation period to go on anyway.
Yes.
So the question was, why doesn't the same apply in that situation to a potential action against someone who isn't a director?
Well, my primary position would be if one assumes the sole shareholder knows and is in a position to cause the company to sue, even when there's a competent director, then again time would run. I'm prepared to push the point that far. Why not? Why couldn't the defendant say, well, hang on, the company knew in the sense that the person who is in a position to control its affairs, i.e. the sole shareholder, knew all about this. He was happy to let the thing go, or he let the thing go anyway. And it's neither here nor there that the director didn't know. I'm prepared to go that far, but I submit I don't have to go that far. I submit we are here dealing with a slightly different problem. And the question I submit we have to look at is, in these particular circumstances, how does one apply the Limitation Acts, which obviously in turn say nothing about the answer.
The outworking of your submission about the position that you're prepared to go to, you said, where the sole shareholder does not convey the information to the competent director, the competent director is nevertheless caught by the limitation period. Is that right?
Company is.
Sorry.
Yes,
well, my lord, that is one possibility. But I mean, I do submit there are different considerations. Well, it is not the case that the same considerations necessarily apply for actions as between the company and its directors who have caused it to do wrong.
Okay.
In circumstances where they simply can't be expected to sue. And cases...
How far you are prepared to go.
Well, I'm prepared to push it all the way and say if the shareholder knows, then that's that. As it were, you could imagine, for example, a case where the ultimate beneficial owner of the company, or as it were, the moving spirit of the company, the sole shareholder, knows all about the wrong. And he's got a puppet director in there who, let's say, for example, doesn't know anything about it. Why couldn't the defendant in those circumstances say, well, the company knew in the sense that the person who could control the company's affairs knew all the relevant facts, assume for the moment it was knowledge as well, and yet did nothing.
Right. Well, we better move on because you haven't got very much time.
No. But my lords, my fundamental submission is the right approach is what is the proper construction of the Limitation Acts? And my lords, can I just say...
Sorry, can I just ask you...
Yes.
I don't want to take up unnecessarily
No.
time, but are you confining your submission to a 100% shareholder, or would it be materially different if it were a 99% shareholder? And if so, you can see how the question arises how far you push it.
Well, my lords, I have my position, 100% shareholder, the position is different in any event. But I would also say, if, let's say, you had misfeasant directors who will never go to sue, then I would submit that if the majority of the shareholders who do know, then that's that. Query what if a minority know. But the reason I say I don't want to get too tied up in different scenarios is because one has to, the right question to ask is, on the facts of this case, or similar cases, is how should one construe the Limitation Acts? What is the intention of the Limitation Acts? My lords, I think it's not contentious that when you have a situation like this, you look at the policy of the statute. And I get that from the Meridian Finance case. What is the policy of the statute? In particular, is the, I think, speech or opinion of Lord Hoffman, page 1526 and 1530. You're looking at, he wasn't dealing there with limitation, but he was dealing with the question, well, what if a person who is not a director of the company does have relevant knowledge? Can it be said a criminal offence has been committed by the company in those circumstances? He said, well, what you've got to do is look at the statute to see what the intention of the statute was. Likewise, I say here, you look at the intention of the statute.
That was more about conduct rather than knowledge as such.
Yes.
Yes.
But, my lords, one starts at the starting point is what is the policy of the statute of limitations? And you get the answer to that in the speech of Lord Millett in the Cave case at tab 12 of the authorities, paragraphs 4 to 8. Page 1418.
Okay. Sorry, at paragraphs?
4 to 8.
Thank you.
My lords, can I just ask you just briefly to read that passage, those paragraphs yourselves, and I'll just pick up a particular point I want to make.
18.
Yes.
And there are 3 points. First is the end of paragraph 5. They're regarded, statutes of limitation are regarded as beneficial enactments and are construed liberally. And then the underlying policy is to give effect, the defendant should be spared the injustice of having to face a stale claim. That's, say, one he would never expect to have to deal with. It's in the public interest that a person with a good cause of action should pursue it within a reasonable period. In common justice, a plaintiff ought not to find his action statute bar before he's had a reasonable opportunity to bring it. Now, in a case like this, where the company, you have a solvent company, you have a shareholder able to bring an action against the misfeasant directors, one asks, on what possible basis is it to be said, bearing in mind the policy of the Limitation Act, that you say, oh no, he can know all about it and do nothing for 10 years? And the consequence of the alternative argument is this: the Minister of Finance can find out all about it. He doesn't ratify it. He doesn't sue, doesn't cause the action to sue. And then 10 years later, he sort of thinks, oh, I better get round to suing these jokers. And apparently he's in time. I submit that's an astonishing result, which is quite inconsistent with the underlying policy, which is you bring an action when you can. And if a company can, through the ministry of the, through the agency of a shareholder, then that's it. And I do submit one has to consider the alternatives. And I submit the alternative I contend was manifestly just and sensible and consistent with the policy of the Act. The alternative which my learned friend contends is completely inconsistent. It could be 10, 15 years, because often governments are in for 10 years in a spell. If my learned friend's right, that's it. You just have to wait for 10 years, despite the fact that you could have been sued all along. My lords, can I make this point? If one arrives at the conclusion that knowledge makes time run, then discoverability must as well. And so one has to start with the example of what if the Minister of Finance knows? If it's relevant that he knows, it's relevant he can discover. My lords, can I also say this? It's very odd. It leads to very odd consequences. My lords, there's no doubt, and I don't understand it to be disputed, that the Minister of Finance in this case could actually have ratified the investment and indeed the negligence. He could have said to the directors, I gather you didn't do that due diligence. Never mind, I'm happy with that. I don't mind about that. And that would have been binding on the company. Likewise, the Minister of Finance could actually have brought a derivative action straight away from the moment he found out, or could have found out.
Why should he bring a derivative action? Why should the Minister of Finance bring a derivative action?
Well, on behalf, he could cause the act. He could
normally
cause
bring a
the
derivative action. You have to show that somebody else is in control of the company. But if you're the only shareholder, you never.
Oh well, in that case, yes. At the very least, forgive me, my lords. Yes, he could do it anyway. He could cause the company to do it without having to bring a derivative action.
Yeah.
Without any need for leave.
Yeah.
Sorry? And without any need.
Without the need for leave, yes. But he can do it anyway. But my lords, that would apply, let's say, to even let's say if you didn't have the sole shareholder situation. Let's say, for instance, you had misfeasant directors, but most of the shareholders have gone to sleep or couldn't care less, but there's 40% who do want to do something about it. They certainly can. They would be able to bring a derivative action. But in my submission, the crucial point, the important point here is, what is the position if the directors cannot themselves sue on behalf of the company? Does one say time doesn't run at all, or does one say, well, no, if the sole shareholder, or at least some shareholders know about this, then time begins to run for the purpose of an action against them? My lords, as to the point about state enterprises, I make 4 brief points about that. What the Court of Appeal's judgment is essentially doing is creating a special rule of non-attribution in the case of state enterprises. In other words, it appears to be saying, well, even if it might be the case in normal companies, when it comes to state enterprises, we think that rule shouldn't apply because of the possibility of corruption or governments not doing the necessary. My submission, that is simply wrong in principle. If it is perceived that there is a problem with governments not suing misfeasant directors of state-owned enterprises, then that's a matter for the legislature to step in and consider the matter fully. It's quite wrong for a court, in my submission, so to speak, to legislate and say, whatever the position in different circumstances, we think there's so much government corruption, we're not going to apply what would otherwise be the rule we'd apply to other companies. That's a matter for the legislature, not for the courts. The second is that the logic of the Court of Appeal's judgment is that, presumably, the Minister of Finance couldn't even ratify a breach by directors of a state enterprise, at least directors he'd appointed. Because if his knowledge is irrelevant, or cannot be deemed, or shouldn't be deemed relevant for the purpose of the Limitation Act, why should it be deemed relevant for the purpose of ratification? One would have thought the same logic would apply to both. The third problem with the Court of Appeal's judgment is this. Supposing the position is that I'm a director who was appointed by a previous government. What then? Does one say, well, can I say, well, look, I was appointed by a different government, and therefore time should run against me because I wasn't actually appointed by this new government. It's absurd. Problems arise. Sorry. Well, yes, and Mr. Jeremy is right to make the point. The consequence of the Court of Appeal's judgment is there's almost endless liability. It could go on for 10 years, potentially. You can't get insurance against that. My Lords, there is a final point I'd like to make. It may be that there's a problem with governments suing the people they appoint to state enterprises. But there is also a converse problem, which is adverted to in Mr. Justice Rampersad's judgment. And my Lords, you'll no doubt know from your own experience, and that is when there's a change of government, there tends to be quite an incentive on the new government to come in and fight, as it were, exercise a bit of political muscle. And as we say, as in this case, basically just bring cases against the appointees of former governments. And my submission, that should not be encouraged. So there are countervailing considerations. My Lords, that's what I say on what you might call the main point of law.
Just before you go, it's inherent in your submissions that you say yours is a general rule of attribution.
General rule of attribution.
Rather than a special rule.
Well,
and yet
yes.
you seem to justify it on the basis of the policy of the Limitation Act.
Yes.
Which would suggest that what you're really seeking to put forward is a special rule, rather than a general rule.
Well,
it may be none the worse for that,
yes.
but it does have implications when you get to stage 2 of the Court of Appeal's analysis.
Yes. Well, I submit essentially it is a general rule that where, if I can put it this way, the problem with using special in general is it gives rise to difficulties. I say the general rule is where the company cannot be expected to sue through directors, then knowledge or discoverability by shareholders is sufficient. That is, I say, the general rule. And it doesn't really form an exception to any other rules because it's always the case that shareholders who are in control of the company can cause the company to do what they want it to do.
So that's a submission which is limited to limitation.
Certainly in relation to limitation, but also ratification. I mean, it's the same as, the shareholder can always ratify. I mean, the Minister of Finance in this case could always have written to Mr. Julien and said, you're fine, okay, I don't mind about that. That would be consistent with the rule that the shareholder can waive effectively breaches by the company, at least when by the directors, at least when the company is solvent. Might be different when the company is insolvent. I mean, I would accept there may be difficulties there, but there's no suggestion of insolvency here. And I say it is consistent with the general rule that a company acts through its directors, but always, as we've quoted in our case, subject, I think, Section 90 or Section 60, subject to the unanimous agreement of the shareholders. And that's the general rule. And also, Section 60 is in the authorities.
Yes.
Standard. My Lords, my third point, and that is the Court of Appeal essentially held that there had to be some trigger which would have caused the Minister of Finance, assuming he was the relevant person, to make inquiries. Now, my Lords, if I can just briefly, I'm going to come to this in a tiny bit more detail later, but the background to this allegation, or to this finding, is as follows. Before the first set of hearings, the respondent alleged that discoverability by the Minister of Finance was not enough. There had to be knowledge or complicity. That was expressly said in its evidence, and I'll come to this later. After the first hearing, it continued to make that assertion, and one can see that in particular, the Court of Appeal then give its judgment, which you see at record 3. Uh, 1024. 1024. My lords, forgive me. After the Court of Appeal gives its judgment, this is how the respondent continues its argument. So page 10.
Is this judgment number 1?
This is, forgive me, my lords, this is a skeleton argument by the claimant. I've misled you. This is a skeleton argument after the first set of judgments for the second hearing in front of Mr. Justice Rampersad. And this is how it's put. And this is where the notion of trigger comes in. And I think, in fact, this is the judgment, this is the skeleton for the Court of Appeal. In other words, the last of the respondent's skeletons, which you see at 1024. I'm just explaining where this notion of trigger comes in. Paragraph 14, they effectively repeat their submissions below, which I'll come to in a moment, which they say there has to be knowledge, discoverability is not enough. But then paragraph 15, the appellants rely on the undisputed evidence of the board minutes. The mere fact there may be evidence that information is sent doesn't mean that the information disclosed any breach of duty. Our analysis in paragraphs 20 to 36 and 70 to 71, which I acknowledge you have to have knowledge and nothing less will do, indicates there was no such disclosure of a breach of duty or anything that would trigger a line of inquiry. So when the Court of Appeal is talking about this trigger, it's dealing essentially with this argument, that there has to be something which would put the Minister of Finance on notice of a breach so that he can be deemed to have knowledge. And then you get the Court of Appeal's judgment, where it essentially adopts this line of argument, which you find at 1042 in the third volume. At paragraph 35.1, there must be something in the documents disclosed to the Minister of Finance that would trigger a line of inquiry. I'm satisfied there was no trigger. And, my lords, you get similar, if I can just give you the references, constant references to the need for a trigger in paragraphs 56, 57, 73, page 1060, paragraph 74, 1061, paragraph 75 at 1061, and also you get the same idea coming in at paragraph 77 to 79 at 1062. The whole time the Court of Appeal is saying, we don't find there was any trigger. Now, in my submission, that was, obviously all goes back to this notion there has to be a trigger. Essentially, the trigger which would mean that the Minister was put on inquiry, or so that he would be taken to know. Now,
isn't this just using the old-fashioned language of discovery as a label for saying there must be something to make it discoverable? I mean, this all comes from Peruvian guano, doesn't it?
Yes. Well,
this language. Well, and it's the language of discovery.
Well, it may be, but, my lords, essentially, my lords, I accept in what you might call a standard deliberate concealment case. That might be a proper, because you assume there has been actual concealment. And then, once it's been concealed, then there's got to be something which would make you realise it's been concealed. But here the question is rather different. The question is in the circumstances, was it unlikely that the breach would be discovered for some time? Which is a different question. And you don't have to have a trigger for that. If the circumstances, and the important point here is the approval of Cabinet being required, or the Minister being required, if it's all subject to approval, then whether you call it trigger or not, I say if the circumstances of themselves make it likely, or not unlikely, that the breach will be discovered, that's it. You don't need a trigger. And this requirement for some legal requirement for some sort of trigger, in my submission, is simply wrong. And my lords, the Court of Appeal never looked at matters as how they stood as at the 17th of May. And bearing in mind the need for Cabinet approval, was it unlikely that the alleged breach would come to light? They simply don't ask that question. They simply assume there's been a concealment for which a trigger is then needed, rather than going back to the earlier question, well, what were the circumstances in which the alleged breach was committed? And in my submission, that was a fundamental error of law. My lords, my next point, the fourth or third ground of appeal, is I say it's simply not open in any event to the respondent or to the Court of Appeal to find against my clients on the basis that the breach was not discoverable by the Minister of Finance. My Lords, I've taken to the pleading at page 427 in the reply, but, my Lords, one can then look at how the matter is put in evidence, and essentially how it was put in the witness evidence. One can pick it up in volume 2, at page 582 of the record, paragraph 11.
I'm so sorry, I missed your page number.
582 paragraph 5. 582 paragraph 5. This is the first round, and this is the evidence of the respondent, Mario Edwards. I'm advised by the attorney for the claimant, and believe that the issue in the claim is, was there any proper due diligence carried out, and so on? And B, if there was no such due diligence, was the corporation sole, the Ministry of Finance, fully informed by the directors of that failure, so that the Ministry of Finance can be said to have given its fully informed consent to the investment without any proper due diligence having been carried out by ETEC? And then, again, paragraph 7, he deals with one of our affidavits by Miss Beverly John, and one can pick it up from the foot of the page, 3 lines down, 583. If it were to be asserted that the ministries were fully informed regarding the failure to conduct any proper due diligence, it would be necessary to show that these matters were specifically brought to the attention of the relevant decision maker. And likewise, I think I'm right in saying paragraph 16, 588, he repeats the point about the need for the Minister of Finance having to be fully informed. In page 595, you can see this is what the judge at first instance in the first round picks up, paragraph 4.
Sorry, page?
595.
Thank you very much.
Mario Edwards deposed to an affidavit and so on. His response was that the provision of the board minutes did not mean that the respective ministers were aware. And then he picks it up right at the end of paragraph 4. In essence, the claimant's response is the defendants failed to fully and frankly disclose all the facts and therefore failed in their duties. And then, my Lords, one can carry on to page 603. Again, in the same judgment, paragraph 38, so paragraph 34, again, the test, and obviously the instigation of the respondent is the fully informed test, because the judge says the issue of whether the Minister of Trade was made fully aware and fully informed, and so on, is far from unequivocally decided. And so forth. And then paragraph 38. And 39, he goes on to explain that, bearing in mind that there's obviously an issue as to whether the minister was fully informed, he's going to hear this matter all at once. He's not going to have a preliminary hearing on limitation. The matter then goes to the Court of Appeal, and you can see how they dealt with it very briefly. Page 621. Paragraphs 22 and 23, they recite our submission saying the question was not fully informed, the question was discoverability. And likewise, paragraph 25 and 26, the Court of Appeal basically agrees with us. So the question is not fully informed or not, the question is discoverability. And at paragraph 43, at page 629, he recites, Mr. Justice of Appeal Barrow recites the respondent's arguments and says they're wrong. Discoverability alone by the shareholders was insufficient. The directors must approve. So again, the whole first round is discoverability doesn't matter. There has to be actual approval. And likewise, you then get 46 and 47, page 631. I consider the judge was plainly wrong to have deferred consideration of the limitation question. The matter must be referred to him to consider it. Paragraph 39, the judge was concerned that to proceed on affidavits before the court untested by cross-examination would be unsafe. He was also concerned about inadmissibility. Those are issues which can be resolved when addressing the limitation issue. But in my judgment, to proceed to trial and hear the entire evidence is effectively to deprive the appellants of the benefit of limitation provisions which are intended to liberate a litigant from the oppression of defending a stale and outdated claim. It's fair that the entire question of limitation under 14.2 be addressed first. If the appellants succeed, it will save costs, and if they don't, it eliminates one major issue. Trial judge didn't have benefit of submissions on behalf of the parties as this court did, and it's right that he should. That apart, it will be for him to decide the manner in which he will hear and determine the application. And that is remitted to him. Now, my lords, you might think in the light of all that the respondent would change its tune and say, OK, right, we're alleging discoverability now, and then there could have been, if necessary, cross-examination, further evidence, and so on. But far from doing that, it simply maintained its position. My lords, all it did was the following. First, it put in a further affidavit from Mr. Hassan Ali, which added nothing in real life. But you can find that at the end of Bundle 2. But I don't think anyone really relies on that. They then put in their submissions, which were advanced on the written submissions on the 15th of April 2013. They put their submissions in, which you can see in Record 3 at page 8. The submissions begin at 830. And you can see how they put their submissions. At 833, they maintain their position. They don't say, they disavow expressly any discoverability case. And you can see how they put their submission at A to E. There has to be some complicity or reckless indifference by the Minister of Finance. And they...
Can I ask you, Mr. Knox, have you... Sorry, on what basis is the... What's the juridical basis for not attributing the director's knowledge to the company? And I'm just wondering if it might be that the directors can't rely on their own breach of duty as an answer to the company's claim. I'm wondering whether it's really a matter of knowledge, or whether it may not be that the knowledge of the company is what it was. It was the director's knowledge, but the directors are unable to found on that, essentially for equitable reasons.
Well, my lords, I don't know if it's being considered exactly what the juridical basis is, but that would obviously be a perfectly sensible one. You cannot attribute to the company that which the person who does know is knowing says to be contrary to the interest of the company, what you might call the adverse interest principle. Yeah. So the company cannot be taken to know through him, but the question then is, well, what is the position if the shareholder does know, for the purpose of the Limitation Act? Mm-hmm. My lords, I think
you get expansive explanations in the terms of that it would produce an absurd result, or I can't quite remember the language used.
It produced an absurd result, and it cannot have been the intention of the Limitation Act in these particular circumstances that the rules should be applied in this particular way. My lords, I didn't take it to the Meridian case, but Lord Hoffman in his speech does say, emphasise in a particular passage, I think I can't remember precisely, but he says, for this purpose, for these purposes, one is looking at how is the Act be construed in these circumstances.
Mm-hmm. I just raised the point because there's a sort of premise here that because the director's knowledge can't be attributed, therefore, as there can't be a vacuum, somebody else's knowledge has to be.
Yes, well, that's my case.
I'm just wondering if that's necessarily right.
Well, obviously our case is someone else's knowledge has to be, and that's the only way of making the Limitation Acts making sense.
You don't have to go as far, do you, as saying that, that it will always be the case that there will be somebody's knowledge which can be attributed to the company. What you're saying is that it clearly can when it's either 100% shareholder or you would say the majority.
Yes. Or sole shareholder, yes. Yes.
Or sole shareholder.
Yes. And also, I'm conscious of the time. I'll do what I can to. I might be a little beyond my allotted time, but not much. My lords, if
Certainly will not be much.
No, well, my lords, if I can just give you. I've shown you page 833. If I can just give you the other references in the skeleton argument, which make it clear beyond any sensible doubt that the argument was being advanced, that complicity had to be shown, discoverability was not enough. If you go to 841, paragraph 18,
Yes.
is plumb, and paragraph 19. They're disavowing discoverability. Likewise, paragraph 20.
But this is all part of their legal argument, as I understand.
It's all part of their legal.
It's not part of their. It's not addressing discoverability on the facts at this point.
No.
It's just saying that you, as a matter of law, where in a situation where the company doesn't have attributed to it the director's knowledge, nor does it have the knowledge of anybody else, such as the shareholders, unless they were somehow complicit.
Yes.
Where that comes from, I'm not sure, but we're not having to deal with that.
It's making a legal submission as to it is advancing its case. It is, if I can put it in this way, the burden, it's common ground, the burden is on the respondent to allege and prove the requirements of that A, the Minister of Finance did not know, and B, it was not discoverable by him. They have to prove the requirements of Section 14.2. They have set out to prove, and they have adduced only lack of knowledge. They put in evidence on that, and they've said you don't get into discoverability as a matter of law. Now, the reason this matters is, after the first hearing, when the Court of Appeal said there must be a preliminary hearing on this, and there can be cross-examination, if at that point the respondent had said, right, well, we're going to take the discoverability point, fine. We would then have had the opportunity of saying, well, let's get some more evidence in, or let's have some cross-examination. But at that point, instead of saying that, what they do is they just say, no, discoverability is irrelevant.
So is your point effectively that they've never denied discoverability?
They've never asserted lack of discoverability.
Well, all right.
But you're right, my lords. I'm being pernickety. But it's for them to assert lack of discoverability.
Yes, I follow the burden of proof.
And they never have, in circumstances where the Court of Appeal has said, we must have a preliminary issue on this, and if you want, there can be further evidence or cross-examination or whatever. And instead of doing that, they've just stood on their position and said, no, lack of discoverability, we're not interested in lack of discoverability, it's irrelevant. Now, in my submission, if that's how they've decided to present the case, when they could have presented it differently, and when we then would have had the opportunity of adducing further evidence or asking for cross-examination, then, my lords, they're landed with it. That's why I say it's so important. And this submission is coming in 15th of April 2013. The hearing was on the 28th of May 2013. So there was plenty of time for them, either before the written submissions or indeed in the written submissions, for them to say, we're taking the point now. And they didn't. My lords, can I just give you the other references? I've shown you, I think, 841, 18 to 20, where it's quite plain what they're saying. And then paragraph 22 at 843, paragraph 25 at 845, paragraph 27 at 846, paragraph 28 at 847, paragraph 31 at 849. Paragraph 33 at 850, paragraph 35 at 851, paragraph 36 at 852. My Lords, it's everywhere.
They still seem to think it's a strikeout application.
Well,
I'm looking at the first 3 lines of paragraph 27, rather than the trial of a preliminary issue.
well, I know. And this is there is a problem here.
Well, because they say certain things must be assumed to be true.
Well, it may be assumed to be true in the sense that there was a breach of duty, for example.
Okay.
But at this point, my Lords, one has to assume the alleged breach of duty for limitation purposes.
Yeah.
But if they're going to run a case of this was not discoverable, they simply didn't do it. And they had the opportunity at this point,
okay.
when, as it were, it was open territory on that issue.
That was about the Tiger valuation, in fact. Yeah.
Yes. And so, my Lord, the hearing, I should say, initially takes place on the 28th. There's a day's hearing on the 28th of May. So the position is that hearing, it's simply being done on the documents. And then there's I think the hearing was adjourned to another day in July 2013. It went over 2 days. And then Mr. Justice Rampersad gives his judgment in October 2013 at Record 3, 969, paragraph 14. And then you get to the Court of Appeal skeleton, which simply maintains the previous position. One can see that at page 1020, paragraph 6, where it deals with our submissions, basically, the relevant one being submission grounds 5 and 6 on page 1018. They say they rely on their previous submissions, but they make the point clear yet again at page 1023, paragraph 13. In terms, if you look at the end of paragraph 13, they're again running the same point, discoverability no good. Likewise, paragraph 14, they again refer to their submissions below, discoverability no good. Paragraph 15 I showed you, and then finally paragraph 56 on page 1032, I think. Sorry, forgive me. I think, my Lord, I'm not quite sure. Page 1052. Forgive me, my Lord. 1052, as you can see how the matter was actually dealt with at the oral hearing. This is the judgment of the Court of Appeal.
Yes.
So, my Lords, I submit it simply isn't open now to the respondents to run this argument. But, my Lords, if I'm wrong on that, then and one does act, it is open to run the argument now. If I'm wrong, then I submit, in fact, just very briefly, the following. First of all, just a few points of law. What does the phrase "for some time" mean? It's a colloquialism. That's the problem. The background, I submit, we deal with this in our case, is manifestly the Bully judgment when I think Lord James says, well, you know, you might build a tunnel under someone's ground and it won't be found out for a considerable amount of time, or phrase to that effect. I should say that I didn't realise this when I drafted the case. There is an obiter dictum by Mr. Justice Lewison, and also in the Court of Appeal in Burndon, where...
We've just heard the appeal from Burndon.
Oh, right. Well, you'll be familiar with the point I'm about to make, where they say, for some time is in contrast with immediately. To which I say, no, with respect, I say that cannot be right. For some time is contrasted with soon. If I say I won't see you for some time, that doesn't mean I'll see you in a day's time. It means it's all in context, but for some time is, in my submission, contrasted with soon. And in this case, in any event, the breach was likely to be discovered almost immediately in any event, and certainly before any damage had occurred. And I say that's good enough. You might say, when was the breach completed before then? But in my submission, the criticism is we made of what we did on the 17th of May. It was likely to be discovered pretty quickly. So I say that's one point.
Does it matter, given the closing words of section 14.1, which starts the limitation period running once the plaintiff, in this case the company, could with reasonable diligence have discovered the cause of action.
Well, yes. Well, in that sense, you mean you don't even get to 14.2?
No, you do, because Section 14.2 stops the period running immediately.
Yes.
But whenever it starts, beg your pardon, although the beginning of the limitation period is deferred by 14.2,
yes,
it starts up under 14.1 once the plaintiff
there are
could
two
with
possible dates.
reasonable diligence have discovered it, doesn't it?
Well, my lord, that's why it matters so much how the case was put against us. Because it's not been alleged there was a deliberate concealment. It would have been helpful, for instance, if it had been said, then we said, well, maybe the minister couldn't have found out within 2 weeks, but he certainly could have found out within 4 or whatever. And that issue simply hasn't been dealt with. But in any way, in my submission for some time doesn't mean not immediately. It means, it means soon. It won't be discovered soon.
So you say, I think Mr. Justice Lewison was wrong in Burnden. So.
Well, it was obiter and dealt with very briefly.
Yes.
And likewise, Lord Justice David Richards in the Court of Appeal, there was again obiter.
Yes.
And in my submission, you should not, the contrast is soon. And can I say a reason why that makes sense? Of course, some breaches are discovered immediately. I bang into your car. Well, you know that. But what if I'm the garage mechanic and I've repaired it? And there are many breaches which are not likely to be discovered immediately, but quite soon. You'll soon find out if the brakes aren't working, or if whatever it is, the gears aren't working properly, and so on. So there's no reason to read for some time as saying, if it's just a few days. That puts it out of kilter with most breaches. Most breaches take a bit of time to discover. Anyway,
does it really matter in this case? Because once the 5 million had been committed, I mean, the real question is, isn't it discoverability at any time after that, before new directors are appointed?
Well, at any time before then.
And their case is that at no time before new directors appointed was it discoverable because there was no trigger. If we didn't know it at the time we approved the transaction. If we did know it at the time we approved the transaction, then limitation doesn't come into it, it's ratification.
Yes.
Well, now, Mr. Knox, you have
Yes. Well,
6 minutes past your indented time, so you must finish soon.
Yeah.
You must not continue for some time.
I won't go on for some time.
No,
My lords, those are my submissions on the law. And we set out in the case what the proper approach is in deciding whether something is unlikely to be discovered. You assume that you do assume that, as well, the Ministry of Finance is reasonably diligent about it, acting in its own interests and so on, and has resources to find out. My lords, can I just deal with the facts? There are two things we say. First of all, the big point is this. On the question of discoverability. The entire the entire authorization was subject to Cabinet approval. That's the big point. Second big point is the Cabinet had considerable doubts in the past about this investment, and therefore it was likely, or not unlikely, that it would look into the question of what due diligence had been done, from which it was likely to work out, or not unlikely to work out, what due diligence had not been done.
yes.
In particular, it was apparent from the information which we provided what the limits of the due diligence were. There was no cover-up. It was quite plain what we'd done and not done. It was obvious we didn't have audited financial statements because we didn't provide any. It was obvious we didn't have a valuation as at the 17th of May because we didn't provide one, and the Cabinet still wanted one. It was obvious the Cabinet would look into legal questions because the note, I think, of the 12th of May makes it plain they wanted to have satisfaction on legal and accounting issues. So if there was any legal problems, then they would look into that as well. In other words, if I can put it this way, if you looked at the circumstances at the time, the 17th of May, is it unlikely the Cabinet is going to realise, is it unlikely the Cabinet will be led into believing you have done due diligence, which in fact you haven't? The answer is no. It was likely to work out that this due diligence hadn't been done. But I come back to my former point, and it's never been said against us that it was the Cabinet was unlikely or the Minister of Finance was unlikely to discover this.
Yes.
My Lords, those are my submissions.
Thank you very much. Mr. Julien?
Lords, I will be brief. My learned friend has covered pretty much everything.
Thank you very much indeed.
But if I could just emphasize the fact that the effect of the decision of the Court of Appeal, which is premised on the tolling of the statute, that's an American term, that is to say the statute does not begin to run until an election is held. That would have very, very unusual consequences in Trinidad and Tobago, where you've had governments in place for 30 years.
Yes.
It would be impossible for directors to get coverage, indemnity coverage for that period of time.
I think Mr. Knox has made that point for us.
And it would be unjust to have directors liable for that period of time.
Thank you very much indeed. And Mr. Guthrie.
Well, my Lord, it may be a relief to hear that I'm not at the moment anticipating requiring the whole of the 2 hours that has been indented for. My Lord, on my learned friend's point that we never properly addressed the issue of discoverability, I'll come back to that in a little detail, but in a sense it's dealt with by the fact that the Court of Appeal plainly did address that question and decide it. My Lord, looking in Volume 3 of the record and in the judgment of the Court of Appeal at paragraph 79, this is the judgment of, this is Justice Rajnorth Lee.
You have a
1062.
thank you very much. Yes?
In her conclusion on this part of the case, she says, having examined the documents referred to above and the evidence before the trial judge, there being no trigger, I am satisfied that the respondent has discharged the burden of proving that there was no discoverability pursuant to Section 14.2 of the Limitation Act. That is the position, and I'll come back in a little while to her, the basis for what she said, but the Court of Appeal was addressing the correct question and deciding it in favour of the respondent. My Lords, I think my Lord Briggs mentioned the question of what was assumed to be the position for the purposes of the proceedings below in the context of whether this was a strikeout or a preliminary issue. My Lords, I have summarized this in paragraph 4 of my written case, which you'll find on page 1152, where I've said that it should be emphasized that for the purposes of the preliminary issue, the basis of ETEC's claim, namely breach of the duty of care imposed by Section 99 of the Companies Act, must be assumed, as also must be the alleged deliberate commission of such breaches of duty on the part of the former directors. And that was accepted by Mr. Justice Rampasad. Well, there's a false reference there. I wonder if I could ask you to correct 977 by 973. I don't think it's necessary to go to it. It's also accepted by the Court of Appeal. It's also been accepted throughout, and indeed is accepted by my learned friend in his written case, that the appellants, in other words, the directors, own knowledge of the facts alleged to amount to a breach cannot be attributed to ETEC. The reference to that is paragraph 17 of my learned friend's written case, which, for the electronic record is at page 1131. If I ask you just to look at that, the only issue is whether or not the Minister of Finance's knowledge or ability to discover the breach of the duty was attributable to ETEC because he was its sole shareholder. The two matters I particularly want to address are, first of all, the question whether discoverability for the purposes of Section 14 can be understood to include matters known to the Minister as sole shareholder. My Lord Reid raised the juridical basis for there being an inability to bring the matter home against the directors, and we would respectfully suggest that it is indeed based on their supposed and assumed wrongdoing. That language is used particularly in the American cases, which my learned friend has referred to in his case, but not in argument today, where the point is repeatedly made that you cannot expect wrongdoing directors to sue themselves, which is a reason for really the concession. And we suggest that the answer to the first question as to discoverability really has to be looked at from the language of the section itself. My Lord said that in Divider 2 of the first of the authorities bundle, and it's set out in various places in the written cases. But under Section 14
Just give me a convenient page.
Yes, of course. I'm sorry.
1188, I think.
It's 1188.
Yes, thank you.
I'm sorry.
Yep.
The sections 14 subsection 1, subject to subsection 3, where in the case of any action for which a period of limitation is prescribed, and then one goes to B, any fact relevant to the plaintiff's right of action was deliberately concealed from him by the defendant, and I would emphasize the words the plaintiff and from him. The period of limitation shall not begin to run until the plaintiff, again emphasizing those words, has discovered the fraud, concealment or mistake as the case may be, or could, with reasonable diligence, have discovered it. And then subsection 2, for the purposes of subsection 1, deliberate commission of a breach of duty in circumstances in which it is unlikely to be discovered for some time amounts to deliberate concealment of the facts involved in that breach of duty. So, Lord, it may be stating something which is simply obvious, but discovered in subsection 2, in the words in which it is unlikely to be discovered from some time, can only mean discovered by the plaintiff. My Lord, it's always been, I think, understood in that way. There's a particularly neat example of that in the case of Cave and Robinson, which your lordships have at tab 12 of the authorities bundle. And it's at page 1431 in divider 60.
Yes.
So that is in the judgment of Lord Scott. It's at the foot of paragraph, about letter F. If the claimant can show that the defendant knew he was committing a breach of duty or intended to commit the breach of duty, I can discern no difference between the two formulations. Each would constitute, in my opinion, a deliberate commission of the breach. Then, if the circumstances are such that the claimant is unlikely to discover for some time that the breach of duty has been committed. The facts involved in the breach are taken to have been deliberately concealed for subsection 1B purposes.
So 14.2 expands 14.1b.
Yes.
But it still leaves you with the concluding words of 14.1, which starts the limitation period when the plaintiff could, with reasonable diligence, have discovered it.
Yes, but then if one then has to look and see who the plaintiff is, and if the plaintiff is the company, I entirely agree with what your Lordship said. But the plaintiff in the present case is E-Tech, the company, not a shareholder, not the minister, not the government. And in our respectful submission, when one applies the words of section 14, subsection 2, they mean what they say. And this has been decided in this way by both the court at first instance and the Court of Appeal in the present case. In our respectful submission, the courts were right, very much for the reasons which they gave. My Lord, I have tried to summarize the position in paragraph 7 of my written case, which is on page 1152. One should not lose sight of the fundamental principle that a limited company has a separate and distinct legal personality from its shareholders. In little 2 of, I have put emphasis added in brackets at the end without actually any emphasis being added in the text, but the words which should have been emphasized are by the company. And we submit that the courts were right to find that discoverability by the minister, the Prime Minister in this case, sole shareholder or not, is not relevant to the question, simply because, first of all, of his separate and distinct legal personality as a shareholder. And we agree with the courts below, each of which paid attention to the fact that a shareholder is not entitled to the benefit of the director's duties, which are owed to the company alone. I've given the reference there to the passage of Justice Rampersad's judgment at 985. And we say that it makes no difference that a shareholder might themselves bring a derivative action, or indeed because is not obliged. The fact that he can do so is neither here nor there. The fact is that that should not stop or interfere with the company's own right of action, which it should retain.
I think the point being made against you is that even if that be so, and the derivative action will be by a different claimant, albeit for the benefit of the company, a sole shareholder, or 100% of the shareholders acting unanimously, could cause the company itself to bring the action.
Well, it could do, but in circumstances such as the present, it could not do. It might not do. And I did accept the assumption that one should assume that it will do what's in its interests or what's in apparent interests. That would be to blur the line between the company on the one hand and the shareholder on the other.
So even if the shareholder can make his own act the act of the company, because he's under no obligation to do so,
yes.
Is it?
Would you say that the appointment of new directors is a sine qua non of the bringing of proceedings?
Yes, in circumstances such as the present, because they're the only persons who would be bringing the action of the company for the present purposes. But
yes, the thing really is that in a case of deliberate concealment by directors, then so long as they remain in control of the company,
yes.
Time does not run.
Exactly. And I appreciate that may, in certain circumstances, have unfortunate consequences, but those were quite squarely dealt with by Rampersad, Mr. Justice Rampersad at first instance in the present case, because the argument was being made in the same way as it's made before your lordships, that it would be unfair if the statute of limitations was effectively told indefinitely until changes of government or whatever it might be. If you look at page 985 of the volume 3, if you're using a paper version, at paragraph 84 of the judgment, we see the judge referring to the argument which has been made to him by the present appellants. It would be grossly unfair to interpret section 14, subsection 2 in such a way as to subject directors who have acted with transparency to legal proceedings some 10 years after the decision was made, etc. And what he says is this in paragraph 85, respectfully, that is not the appropriate test. The suggestion of the possibility of there being a disincentive ought not to arise. Any job carries the potential of legal proceedings if there is a failure to act properly. The potential subjection of any director to legal proceedings is a reality which hovers over every board to ensure that decisions made and conduct carried out are properly done to the appropriate standard and can be policed and remedied if appropriate. The burden lies on the claimant, however, to show that such a breach did occur and that it was deliberate. If it is proven after a full trial, there's no reason to introduce a public policy element.
One thing to say that liability is an ever-present risk. It obviously is. Is it possibly another thing to say that indefinite liability is an ever-present?
Well, that is dealt with by the courts below as well. There's reference to some observations in the first instance part of the decision, I think by Mr. Justice Peter Smith, in the Court of Appeals judgment, which if I can just, it's the case about the Zambia case. The Zambia case, yes, in which, sorry if I could just find the reference, I'm sorry.
Well done.
It's at, we have, yes, it's at paragraph 91.
You have a page number?
Page 1067, I'm sorry.
Okay.
And this part of the Zambia case was, I think, reversed in the Court of Appeal, but not on any point relevant to limitation. It's on page 1068 at the top, paragraphs 385 and 386 of the judgment of Mr. Justice Peter Smith. He observed that the primary purpose of the limitation Act was to provide for a claim to be brought within a reasonable period, or put another way, to avoid people having stale actions brought against them. When a party was aware of a claim, it was not inappropriate there be a reasonable time limit for which a claim was brought. He went on to consider the counterpart to that purpose, where parties were the subject of dishonest conduct. The balancing exercise as against stale claims is that when parties were defrauded or were the subjects of dishonest conduct, they were not to be disadvantaged until they had an opportunity to discover the wrongful acts. The rationale for such an approach is that it's an unsatisfactory state of the law if people who have behaved dishonestly could escape liability by successfully hiding their wrongdoings for the period of the primary limitation
We have
period.
to assume that this case falls into that rather nebulous and possibly quite narrow undistributed middle between dishonesty and deliberate breach. Because generally speaking, the deliberate commission of a breach of duty in circumstances where it's unlikely to be discovered is probably dishonest. But I think, as Mr. Knox said, this
Yes, we haven't gone so far. We haven't gone so far in this
fairly
case.
rare category where that's not so.
But so far
If that's
as
right, why does Mr. Justice Peter Smith's analysis help? Because he's talking about cases of dishonesty.
well, what I think.
Doesn't help anyway, does it? Because the whole point is that what he's saying is that if you conceal what you've done, you can't complain if you're not sued until the person who's suing you has found out. What's said against you is that in reality the company had found out about all this from the beginning.
Well, Lord, I come on to that because that's found not to be the case on the facts in this,
That I understand.
in this case as well. But surely the principle, which I attempted to summarize at one point in my written case, was that this is an example of a case where the company did not discover, was not in a position to bring the action until it knew the facts, and both the courts below have found it was that case. I think it's paragraph 17 of my written case. Mr. Knox's criticism in his written case is that it's contrary to one of the main purposes of the Limitation Act to prevent bringing of stale claims, save in special cases such as fraud and the like, where the claimant does not and cannot know that he has a claim. And we say that our claim is an example of just such a claim, because the present board could only know that the company had a claim after the departure of the appellants, the previous board. So they invoke section 14, subsection 2 in those circumstances, and both the courts below have decided, as we submit quite correctly, that they're entitled to do that. The element of dishonesty doesn't alter that proposition. It's, I mean, the reasons which have been developed are either correct or not, but we submit it would be wrong to go outside, if you like, the plain meaning of section 14, subsection 2, by allowing the discoverability to be attributable to someone other than the plaintiff, other than the company itself. And that indeed there is no sensible justification for a rule which would apply to some shareholders or sole shareholder rather than another shareholder. Because there was some acceptance of the inapplicability of section 14, subsection 2, to an ordinary shareholder, if I can say that, other than in certain circumstances, in present circumstances, where in the arguments of the appellants below, it was accepted that section 14.2 would be likely to be found to apply if the only person with knowledge was a minority shareholder. Well, that is, I think, at page 1156, one sees the argument being made would be in volume 3. Yes, I'm sorry. I've given myself a wrong reference. It's at 1013, I'm sorry.
I'm sorry, page?
Page 1013. See? It's a paragraph which begins, the Canadian authors say, and Mr. Justice Rampersad appears to have accepted, the knowledge of shareholders should be ignored because a shareholder is not an agent of the company, has no power to bind the company, has no duty to protect the company or to institute a derivative action on behalf of the company, and accordingly his or her knowledge ought not to be imputed to the company. One must concede the force of this argument in relation to a shareholder who is one of hundreds of shareholders of a publicly traded company. The fact that he or she to know of the circumstances of the culpable director's wrongdoing could not, in all fairness, prevent time from running against them. In such a case, one would expect to hold Section 14 to be applicable. We say, as a matter of principle, the distinction to be drawn is between the company and the shareholder, and not between one of a number of shareholders and a sole shareholder. There may be reasons why a sole shareholder does not wish to bring proceedings. The fact that he does not do so should not prejudice the company if and when it is in a position to bring proceedings, and doing so at a later stage.
The sole shareholder may not want to.
Yeah.
And
if so, then the company should not be prejudiced. Quay company. Well, really, I don't think I have a great deal more to add on the first point that I wanted to address. The second point...
Can I just ask you this? Do you want to say anything about Mr. Knox's point that if the knowledge of 100% or sole shareholder, let's use that for present purposes, plus consent to the relevant transaction is enough to bind the company by way of ratification, why shouldn't that same knowledge be attributable in this context for the purposes of the running of time for the taking of proceedings to disapprobate the transaction?
Well, I suppose, without wishing to enter into it, why should it be relevant if the...
One's tempted to say what's source of the goose is source of the gander. And if there is a principle which may loosely be described as one of attribution for the purpose of deciding the circumstances in which 100% of the shareholders have ratified some piece of conduct so as to disable the company from suing the directors, multinational gas example, but why should not the same principle of attribution work in the opposite situation?
Well, in a sense, that assumes...
Not to disapprobate, but consider whether to sue.
It's a hypothetical situation because it assumes what we say is not the present situation, that the sole shareholder does indeed have the whole of the knowledge of the...
Of course, I accept it operates in that context, and ratification requires full and informed consent.
Yes.
Yes.
So he would have to know of all the details, and that simply is not this case, as we respect facts. But the problem is avoided if one sticks to the fundamental principle that the shareholder and the company are distinct and separate legal personalities. So I was coming on to the second principal point, which is if discoverability by the minister, the Prime Minister, as we know, is relevant, then the defendant's case fails on the facts. And I've already taken you to the finding in the Court of Appeal, circumstances that the respondent had discharged the burden of proof that the defendant's breach of duty was unlikely to be discovered for some time. There was certainly evidence before the court to that effect. Lord, we identify what we say as an error in the insistence on what happened on the 17th of May as being the be-all and end-all of the plaintiff's case. The plaintiff's case is rather broader than that, and that there was no due diligence. The discoverability of that does surely depend on there being something drawn to the attention of the minister which will lead him to suppose that a breach of duty has occurred. We don't accept that the use of the word trigger or the trigger test is in any way justified. I respectfully agree with what was postulated to Mr. Knox in argument that all that's really being said is the language of discovery. The absence of a trigger or some cause for suspicion that all is not well can really be seen as part of the circumstances in which discovery by the claimant for some time is unlikely, unless the sole shareholder, the minister's attention, is drawn to something being wrong, then the circumstances are likely to be those in which discovery from some time is not to be expected.
Where there has been a discussion between the sole shareholder and the directors about the due diligence which is required, and a report by the directors in respect of some of it, or precious little of it, perhaps, but at any rate, there's been a report back. Is there anything or not to lead to put the shareholder on inquiry? And you can call it a trigger if you like, but why isn't it a trigger?
Well, because there's no need to assume that because one is not told of something in terms that it has not taken place. And in fact, if one looks at the evidence of Mr. Edwards, which my learned friend criticises on the basis that he has, it's at page 581, I think.
Not being told that something has taken place, it is not being tipped off that it hasn't.
Well, my learned friend says, well, we were being informed of certain things which we might have regarded as, if you like, the limits of due diligence. But surely it's not for the minister to second guess the board as to the extent and satisfactory nature of the inquiries that have taken place. The fact that he is not told something is just as important as the fact that he is told something, but why is he in the position of assuming, and indeed it goes rather further than that in the present, why is he in the assuming that the limits of what the directors have done are such that they are likely to have been in breach of their duty under Section 99 of the Act? Well, it's at 581, I think, that the affidavit begins. The important parts, if you like, are at pages, begin at 583, paragraph 6. He says he's advised by his attorney and believes, with respect to the evidence that has been put in by the appellants, that those failed to address the issues of any clarity or at all. Affidavit of Beverly John. Ms. John asserts that all the board minutes were sent to the Ministry of Trade and Finance. I'm advised by the claimant's attorney and verily believe that this does not of itself show that those ministries were aware of the lack of any proper due diligence. As a matter of common sense, in fact, the Prime Minister is not going to be going through all this information with a tooth comb. Decide whether he thinks the directors are doing a good or a bad job in every respect. There's now a producer shown to me a document entitled Bamboo Networks, etc. This document was produced by Ms. Fitzwilliam, who is the Vice President. The document demonstrates the failure to obtain any of the relevant documents which would have comprised proper due diligence prior to the investment being made. None of these matters appear in any of the board minutes purportedly sent by Ms. John to the ministries. if it were to be asserted that the ministries were fully informed regarding the failure to conduct any proper due diligence, it would be necessary to show that these matters were specifically brought to the attention of the relevant decision-maker in those ministries by ETEC. I respectfully submit that's a perfectly sensible thing to say. Ms. John also states that Mr. John Suping Chow represented to the Finance and General Purpose Committee the results of his due diligence performed on BNL, which included a physical visit to Hong Kong to see BNL's operations. I'm advised and believe that this statement hides more than it reveals, should thus be placed in the context of what actually occurred. First in December, and that's the reference to the visit which led to the Ministry's advice that it shouldn't invest. ETEC board meeting on the 18th of January, Mr. Suping Chow made a presentation regarding BNL's finances. This was based on BNL's unaudited accounts for the period of 2nd January to 4th of August 2004. Prior to the investment made, Mr. Suping Chow was not in possession of BNL's audited accounts for any period since its establishment. Secondly, there's nothing to indicate that ETEC, following the visit to Hong Kong, carried out any due diligence to assure themselves the facilities they saw in Hong Kong legally belonged to BNL Cayman Islands Limited. And then there is a reference to the presentation to the Finance and General Purposes Committee on the 9th of May. The position was limited. That is why the Cabinet instructed ETEC to address certain concerns. I'm advised by my attorney that those required further due diligence and independent valuation of the shares. The evidence shows that ETEC relied on what it was told by BNL was a valuation of BNL. The valuation was fictitious. And then it continues. Paragraph 15, Cabinet requirement set out was completely disregarded, or the board failed to ensure that its terms were fulfilled. The result was that ETEC invested in a straw company. Then he makes similar comments in relation to the affidavit of Eugene Tyre. Well, Lords, this material and the documents which were disclosed was considered in some detail by the Court of Appeal in the judgment. And your Lordships will see that at 1039 in the judgment of Mr. Justice Barrow, at paragraph 24. He refers to the arguments made by the appellants below in paragraph 23, page 1039 this is. And he says, the summary of the submissions is the breaches of duty, albeit assumed, were discoverable by the shareholder. It did nothing and allowed the statute of limitation to expire. The submission, although attractive, cannot succeed. In the first place, the evidence does not support the submission. It is not correct to say that the Minister of Finance and the appellants behaved as if the Minister was totally in control. In my judgment, the appellants, as a board of directors, took an informed decision to make the investment. It was not a question of blindly following the directions of the Cabinet. They were advised by professionals. When the Minister and the Minister of Finance advised that the investment appeared to be a bad one, the appellants endeavoured to persuade the Minister of Finance and the Cabinet of the viability of the venture. This was not a board mindlessly following the policy or directions of Cabinet. Rather, it was a board which took a calculated decision to proceed with the project and to persuade the Cabinet of the viability of the project. It directed an independent mind to the project, then persuaded the Cabinet of its viability. In these circumstances, I cannot agree that the parties behaved as if the Minister of Finance was totally in control. Moreover, to impute the knowledge of the Cabinet to the company by way of a special attribution is highly undesirable in Trinidad and Tobago at this stage of our economic political development. Then he goes on to make the point for which they're criticised. In my respectful submission, the, so to speak, political ramifications of their decision was not a matter upon which they appear to have based their conclusion so much as one which they treated as being a desirable consequence of them, or confirming that they were.
But this is really about a careful addressing of the factual question of discoverability. This is all about whether there should be a special rule of attribution.
Yes.
as we see at the peroration of paragraph 27.
Yes.
Yeah.
But the facts of whether or not there was discoverability by the minister, certainly Mr. Justice Barrot was saying, well, the minister and the company were not hand in glove with one another. The same issue are really considered in more detail by Reginald Leadjay, Justice of Appeal, and she deals with it in some length with the evidence in the context of the trigger, which I've already submitted as a perfectly reasonable way of looking at it. At page 154, really, it begins at paragraph 58. She goes through the documents which have been shown to your lordships today by Mr. Knox. And it's really, having done that, at paragraph 73, she says what's in issue in the context of section 14, subsection 2, is whether those documents and any other document which would act as a trigger were disclosed to the Minister of Finance. From the evidence before the trial judge, there's no indication that any of the documents referred to above were sent specifically to the Minister of Finance. As a member of Cabinet, he would have received the documents which had been provided to the Cabinet. I wish to add that it does not appear from the evidence the Ministry of Trade and Industry and the Cabinet had notice knowledge of the letter dated the 30th of December from the Minister. There's also nothing in the evidence to suggest that the documents which were made available to the Minister and the Ministry of Finance would have been disclosed to the Minister. The question that remains, therefore, is whether the documents provided the Cabinet provided a sufficient trigger for the Minister of Finance. I've considered the note, and she goes on. In my view, it does not constitute a trigger that would have put the Minister of Finance on notice that a breach was being or about to be committed. Indeed, the note was presented to Cabinet as one of the documents that satisfied the conditions imposed by Cabinet in its minute dated the 12th of May. I'm also in the view there was nothing in the cooperation shareholders agreement to act as a trigger. I'm also of the view there was no trigger in the letter dated the 18th of May. The first appellant drew to the attention of the Secretary of the proposed agreement, etc. I've also examined the note for Cabinet prepared by the Ministry of Trade and Industry. I'm of the view there was no discernible trigger in this note. The Minister had concluded that BNL would be profitable by 2006. She then refers to the minutes of the board meetings and the affidavit which I took you to at paragraph 78 of the judgment. And she reaches the conclusion that I've already directed you to, that taking all that material into consideration, she did not find there was anything there which would bring the discoverability provisions in section 14, subsection 2 into play.
What do you say is the effect of the decision of the judge second time round and of the Court of Appeal? It's dismissed the application to strike out.
Yeah.
Does that resolve once and for all the question of limitation?
Not insofar as, well, there's the express reservation made by Mr. Justice Barrot and agreed with by Madam Justice Reginald Lee. I think it's at the end of Mr. Justice Barrot's judgment.
Proving the deliberate breach. Yes.
Yes. What he says.
But otherwise, discoverability is resolved once and for all. Okay.
Well, my lords, I think as I said, there were two particular points that I wanted to go through. But your lordships have all the documents in our written cases, and unless there's anything further that you would want me to deal with.
Thank you very much indeed. Mr. Knox.
My Lords, can I deal with the main point of law?
Yes.
My Lords, my learned friend rightly points out that in section 14.1 the deliberate concealment must be from him, and therefore, as it were, when one's looking at section 14.2, it must be a breach which is not discoverable by him. But our whole point is that for the purpose of the Limitation Acts, in this situation, you attribute the knowledge or discoverability of the sole shareholder to the company. It's not our case that the minister can bring an action, it's our case that the minister can cause the company to bring an action. And therefore, it is his knowledge which is to be attributed, or discoverability, which is to be attributed to the company. We're not asking for an order. We're not saying the minister is the person who brings the action. It's the company who brings the action. His knowledge is simply attributed to the company. And my Lords, can I just, in this context, take you to a passage, this question of attribution, a passage in Lord Hoffman's judgment. I mentioned it without taking you to it, but it's at tab 18, 1526. And I submit, really, it is the, it sets out the nature of the problem. Not in this case, but it is the problem we often get with statutes in a particularly succinct way. And I submit provides, so to speak, the tools with which one can answer this question. It's at 1526. And it's the passage which begins at 1526b. The company's primary rules of attribution and so on are usually sufficient. And it finishes at F. Can I just ask you briefly to look at that, in particular, the second of those two paragraphs? As I submit, this is really the correct approach in deciding the question.
Yes.
And essentially his point is there are often cases in the statute when you can't really, it's not obvious what the answer is. And so you then have to, he says at D, there will be many cases in which neither of these solutions is satisfactory, in which the court considers that the law was intended to apply to companies, and that although it excludes ordinary vicarious liability, insistence on the primary rule of attribution would in practice defeat that intention. In such a case, the court must fashion a special rule of attribution. This is always a matter of interpretation. Given that it was intended to apply to a company, how was it intended to apply? And then importantly, whose act or knowledge or state of mind was for this purpose intended to act?
So attribution varies with the context.
We look at the context. And obviously the statute of limitations says nothing about this particular question. So the question for the courts is, well, bearing that in mind, whose knowledge, if anyone, is to be attributed?
The trouble with that in the limitation context, that it's inconceivable that one can discern from the bland language of the Limitation Act anything more than it was intended to apply to companies.
Yes.
So him means, in the case of a company, it. That doesn't of itself give one any real help as a matter of construction for that rare kind of action, namely by a company against its own directors. And at that point, unless one's left with the possibility that in such an action there is simply no mind, the knowledge or ability to discover something of which is attributable to the company in that rare instance of a company's action against the whole of its existing board.
Yes, that's a possibility.
And the other possibility is in a case where there's a sole shareholder or a majority that work together rather than a number of individual tiny shareholders, it's the shareholder.
Yes.
I'm not sure, does one really get much? I mean, one then has to go to some special rule, doesn't one? And that's where you rely on the overarching purposes of limitation.
The problem is you've got in this case, a situation which departs from the usual situation.
Yes.
And so the question, what then? Do you just say, you hold your hands up in horror and say, well, we can't do anything about it? Or do you say, well, that being the case, then it must be the intention of the Act that if there is someone who controls the company and can indeed cause it to bring the action, is his knowledge relevant? And I say, you have my submission.
Yeah.
I say that's the fundamental point.
In this case, I don't think you're suing all the directors, but you're suing all the directors who were...
being sued.
Well, I'm not doing anything.
I beg your pardon. You are.
Not yet.
You are. You are, I think, not all the directors, but you're all the ones who were present at the critical meeting
Yes.
of the board.
Yes, I think that's right, yes. I'm not sure whether there were other directors, but certainly all...
I think there's one who's recorded as being absent.
Yes. Yes.
And your argument would your argument mean that if the directors were also the shareholders, then although you disregard their knowledge as qua directors, you would have regard of their knowledge as shareholders?
That might be rather different, because as I understand it, there is authority in the context of ratification that where the directors are indeed the shareholders themselves, that the rule may not apply. It's referred to in the multi-gas case as a decision of Lord Justice Templeman, I think, which the Court of Appeal distinguishes in that case by saying, well, we don't have that situation here. What we've got here in the multi-gas case is separate shareholders from directors. Query what the position is if indeed the shareholders and directors are all the same. Now, that might be a rather different position, because the logic would be, well, they're never going to sue themselves anyway, qua shareholders.
Same
The fault of the directors.
Yeah. So if the rule applies, so that it may be in those circumstances a slightly different rule. Just as you do for ratification, so you do for limitation. I mean,
And if you had a minority shareholder who wanted to bring proceedings, he would have held against him the knowledge of the majority shareholders who had been the directors at the time.
He would, yes.
Yeah.
Yes.
I'm wondering why you're not seeking to rely on the previous page. That's 1525.
The unanimous decision.
Letters C to
Yes.
E, yes.
Oh, my lords,
Where Lord Hoffman treats the implications about attribution flowing out of what he calls the multinational gas principle as primary rules of attribution.
Right, yes. The unanimous decision of an insolvent company and so on. Yes, we certainly do rely, and I think in our case we rely on it. It's 1525, yes. It is the decision of the company. That's obviously acts of the decision of the company. If acts of the decision of the company, surely knowledge, which can lead to action being taken, likewise must be attributed to the company. That might be the simplest way of putting it. And in a sense, it all tied in with our, what you might call our ratification. My lords, just briefly on the other points made by my learned friend, Mr. Guthrie. He talks about the justice of the position. As I think was pointed out, the importance about Section 14.2 is it applies not only in a fraudulent case, but in a non-fraudulent case. And that, in my submission, is another reason for saying that time should just never run against the directors. One can see if it was necessarily dishonest to commit a deliberate breach, then possibly there might be a different answer. But my learned friend is saying even when there's no dishonesty, then there should be an eternity, effectively, before, or possible eternity. That can't be right. The third point in my submission is this: if in fact there is what you might call dishonesty, it is very likely, not inevitable, that there will be a continuing breach of duty anyway. That's not alleged against us, but that is always a possibility. Let's say of dishonest directors, it would be said you were in continuing breach of duty by your failure to disclose. You ought to have disclosed. And that would actually have the effect of giving time, or rather allowing time, stop it, or time would keep on running from new dates. But we're not in that position. My lords, on the trigger point, our criticism of the Court of Appeal is one of law, not of the way they're approached. And there are two criticisms. First, we say they never asked themselves the Section 14, subsection 2 question in the first place. They simply didn't turn their minds to. In the circumstances, was the breach on the 17th of May unlikely to be discovered? That's not the question they looked at. They didn't look at that. And they never, and they omitted, they don't mention at all, that the whole question was subject to Cabinet approval. And I submit that's the most important part of the case, and they simply don't look at that point. But the other error in my submission is, and I do submit it's an error of law, was that my learned friend says, well, the Court of Appeal has dealt with the discoverability point, to which my answer is it should never have done so. That was not the case we came to meet. It's not right that we meet one case, and then if my learned friend is right, the Court of Appeal then finds against us on another.
Well, come on, the first Court of Appeal returned it to the judge specifically so that discoverability could be decided, didn't it?
Precisely. And that, I agree with that. But there, my lord, for the reason I've taken the evidence, but they simply maintain their position.
I see.
That's my point. They didn't say, okay, right, okay, we're now going to run.
In other words, you say you didn't get the chance to ventilate the arguments that you would have done because the material wasn't produced to the
Well, the assertion wasn't made that it was discoverable by the minister.
But if it had been made, it would have had to be supported by material, or at least you'd have the opportunity.
One way or the other, material or cross-examination. You said, okay, well, if you're saying that, tell us why you say that. Yeah. And then we would have either reduced our own evidence or reduced cross-examination, or got more evidence in. And I submit that is fundamentally unfair. That's why it's so important to see how the case was run. So I said that's the second reason. It's not open to the Court of Appeal, bearing in mind the way the case was run. My lords, I just look at my notes. I don't think I've got two other things. One is the question, tiny. One is the question of the audit. Had other accounts been audited before the 2005 accounts? My lords, the indication is yes. I don't think it's alleged against us that they weren't, but can I just take you to where you get an indication? And that is in the first part of the record, at page 98. Sorry, I should start actually at page 100 and, forgive me, I should start at page 120. And you can pick it up at the foot of the page. What's happening is Bamboo are being chased for their accounts in relation to 2005. And at the foot of 120, Bamboo send us the final, what they call the final draft account, 2005 from Baker Tilly. The audit opinion has been changed to qualify on the disposal of the subsidiary. What had happened is the subsidiary had been disposed of by Bamboo in February 2005. And then Mr. Kim of Bamboo apologises for delay, and then we complain at the top of the page, or ETEC rather complains, that it's all in draft. But you then have the draft accounts at page 100, which begin at page 97. They're audited, well, supposedly audited consolidated financial statements. They're said to be draft. But what you pick up from this is, albeit in draft, they are obviously quite well advanced. But the important point is, in relation to 2004, you can see figures for 2004 being entered. Now, they don't say in terms, these are audited 2004 figures, but the chances of Baker Tilly having prepared accounts like this when there hadn't been audited 2004 figures, I submit, are very low. And there's no suggestion in the evidence, as far as I'm aware, that there were never any 2004 accounts, audited accounts. And one can just see a small point, I think, at page 114. This is when the accountants are talking about subsidiary companies. You'll note there's a little asterisk at the foot of the page, audited by a firm of certified public accountants other than, and that's a company called Rich Pictures, halfway up the page. I mention that simply because it would seem, certainly one of those accounts have been audited, one of the subsidiaries accounts have been audited, and I submit it's very implausible to suggest that there hadn't been audited accounts ever for 2004.
Yes.
My lord, the final thing is the matter of disposal.
Yes.
Now, if I'm right all the way through, then obviously I want this, I say appeal allowed and case dismissed. Your lordships theoretically might say, well, you're right on the legal point about attribution, But don't think you're right, or not prepared to say you're right on the discoverability point. But that's, as we're still in play, should still be in play. Now, my lords, my primary position is, for the reasons I've given, that this whole appeal should be allowed. The respondent had its chance to put its case on discoverability and didn't.
Yeah.
My alternative position is, if you're against me on all that, then the matter will have to be remitted, if you're with me on the first point, it will have to be remitted, I suppose, either to be heard at trial or, unthinkably, I suppose, for another hearing on limitation where full evidence is heard on the discoverability by the Minister of Finance point. But I suppose that's a further reason why it's wholly unsatisfactory. We're now 11, 12 years on or something.
Yeah.
So, yes, my learned friend points out one of the directors is 90 years old. We are talking about people who are getting relatively advanced in age.
Thank you very much.
Those are my submissions.
Thank you very much, Steve. I'm very grateful. I, in particular, am very grateful to the Council for accommodating us. The Board will take time to consider its judgment and will deliver it in due course. Adjourned.